Do I have all the parties on Demetrius Young?
Ready.
I believe so. Mr. Postuma, I think he just has to unmute himself, maybe. Or he's signing right back on right now.
Okay. I'll give him a second. Is he signing in? All right, let me call something else so he gets on. Do I have the parties on Eldape? Mr. Bloomers?
People are ready.
Ready, Your Honor.
Calling case number 2158999, the people of the state of Michigan versus Sarah Adalpe. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. This is scheduled for probable cause conference. Thank you.
Good morning, Your Honor. Jacob Bloomers, T77307 on behalf of the people.
Good morning, Your Honor. Mark Magidson on behalf of Sarah Adalpe and number 25581. She is not present. I would ask to waive her presence. She did call the court and explain to your clerk that she does not have Zoom capability. I did call her and spoke with her at length and indicated to her that I would be looking to waive her presence.
So ordered. Thank you. What's your pleasure today?
I would request an in-person preliminary examination.
Do you have discovery?
I have discovery. The only thing I don't have, apparently there was the complainant was allegedly filming the transaction, and I don't have that. So if at some point I could get that, that would probably complete my package.
Mr. Bloomers, did you hear that request? Is this a Mr. Bloomers case?
It is Mr. Bloomers.
Sorry, Judge. I was muted. I don't have that cell phone video at this time. I do have a couple of, it looks like body cams that I will get to Mr. Magidson once I have a chance to review them, but I will reach out to the OIC regarding the possibility of that cell phone video.
Okay. Is there any concern regarding bond that might affect when I set this for an exam?
No, Your Honor. At this time, it is a personal bond with a no contact order. There is not a tether in place. However, I spoke with the complaining witness and they are comfortable with the bond as it stands.
Okay. Madam Clerk?
September, October?
Yeah.
September 21st at 10:30.
Very well.
Okay, in-person exam September 21st at 10:30 in the morning. And Mr. Bloomers, I'm assuming you will receive that digital discovery. If you can make sure you tender that to Mr. Magidson straight away.
Yes, Judge.
Thank you, Judge. See you, well, probably beforehand, but see you in September.
Yes, sir. Thank you.
Does anyone else need to check in?
On Demetrius Young, Mr. Postuma said he has a case being called in Third Circuit Court, so we'll be on as soon as possible. He said it should not be long.
Okay, I'll just watch for him. I don't have.
Thank you very much.
I'm waiting on him. And Mr. Chambers signed on earlier, but he had to sign off too, so they'll be back.
I can't leave without the rain.
Good morning, Adam.
I'm sorry.
How are you today?
Good. Oh, and I see another one, Davis,
Which one?
John Davis. That's at 11:32.
Probably because it was a DV.
Yeah.
I know what Bigger is now. That's the one that he was, living in a homeless shelter and his phone wasn't working and they were gonna do a comp hearing and they said they're not, they didn't wanna do the comp hearing. That's what that case is. That's why you said it so soon. Remember he said he was going away to school, but then he said he was gonna check himself into the clinic and. So he may not even show up. Do we have anybody out there by chance on the 9:30?
I can check. Gotta be a negative.
All right. We got stuff to do here.
Attorney only.
Oh, Mr. Parker's out there?
Yes, ma'am.
Okay.
what we here for.
And are they in custody, John?
No, they're out. Judge,
Yes.
um,
I
so
just realized sometimes I'm challenged with my timing.
So they have an exam.
Yeah.
Alex is wondering if she could do it.
Hmm.
It's going right now.
Oh, it's gonna proceed right now?
Yeah,
What kind of a case is it?
Arno.
Which one is it?
The Emerson?
Oh, at 9:30?
Yeah.
Yes. So long as, and I don't mean it as like, but so long as it's not going to infringe upon anything else, because my timing is really tight.
It won't.
All right.
Very, very fast.
I welcome you to do it. Yeah, it'll be fun. We'll make it fun.
Bear with me.
And what's your name again?
My name's Alex. Well, I go by Alex, but it's Alex.
Okay, so just prior to you, calling the case, I mean, not prior to, once the case is called, just put that language on the record and that you're working under the supervision of Ms. Yafuki. Okay?
Thank you, Judge.
Yeah, you could just write here. Is Mr. Parker in the hallway?
I think we must have a different attorney.
Oh, yeah. Okay, let's call it.
So we can call it.
Yeah.
They're ready.
If you see Mr. Costello, Judge, you can call that other. Or Arnie and Brinker. Are we ready on Amerson?
Yes, ma'am.
So you took over for Mr. Parker?
I did, yes, ma'am.
What's your PIN number?
85191.
Calling parties on Amerson, case number 2057746. The people of the state of Michigan versus Kendra Latrice Amerson. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, police officer assaulting, resisting, obstructing. Count 3, police officer assaulting, resisting, obstructing. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Alexander Hand requesting permission to practice pursuant to MCL 8.120 under the supervision of YYYYY.
Yafuki.
I apologize.
That's okay.
P82800.
Granted.
Good morning, Judge. Lauren Anderson of the Neighborhood Defender Service on behalf of Ms. Kendra Amerson. She is present in court. My P number is 85191.
Thank you and good morning. Could you please state your name? Thank you. And good morning to you as well. All right, we're here today for a preliminary examination. Are there any preliminary matters to tend to before we start calling witnesses? Madam Prosecutor?
No, Your Honor.
Madam Defense? No, Your Honor. First witness?
Your Honor, the people call police officer number 2.
Okay.
Spell your name, please.
Yeah.
A-L-E-X-A-R-A-A-N-D.
Good morning, Officer Rice.
Robert Hand.
Oh, it's Alexander. Okay, thank you.
Good morning. Could you please come forward if you're on this case, please, ma'am?
I promise I won't bite. Can you please state your full name and spell your first and last name for Madam Court Reporter here?
Officer Lisa Latu, Lisa, as in Tom, OUF as in Frank.
Thank you. Would you please raise your right hand? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth? Thank you. Make your way over here. This half gate will open up towards you. And once she's settled, Madam Prosecutor, you may proceed.
Please state your name for the record?
Lisa Latouf,
Are you currently employed?
yes,
For how long?
3 years.
Where are you currently employed?
Detroit Police Department,
And were you working in that capacity on June 7th, 2020?
yes,
And did your duties as a police officer take you to 19343 Rio Pell Street?
yes,
Is that in the city of Detroit, County of Wayne?
yes.
And what, if anything, brought you to that location?
There was a police run for felonious assault, so my partner and I made the location to assist the primary unit based on the circumstances of the run.
Okay, and then what was the circumstances of that run?
I was a felonious assault, and I believe there was a knife involved.
And what did you see when you got to that location?
When I pulled up, there was already officers on scene. I observed a crowd of people standing outside in front of the location that the run was at.
Okay, and then, I apologize, when you said that you pulled up, were you with a partner?
Yes.
Okay, and then what, if anything, did you and your partner do when you got to the location?
So while we were en route, we had our CAD notes that told us what the run was about. There was a suspect, it was gonna be a female wearing a army dress, and that's who we were looking for when we pulled up. When we did get
I'm
there,
gonna stop you there, sorry. When you got to the location, did you see an individual matching the description?
yes,
And do you see that individual in the courtroom today?
yes,
If you see that individual, would you be able to point to them and point out an article of clothing that they're wearing?
yeah, she's sitting right there wearing a white t-shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
The record will reflect identification of the defendant, Emerson.
Did you make contact with the defendant at the location?
Yes.
And what, if anything, happened when you did make contact with this individual?
When I approached, Officer Sanchez was also standing next to her, and he had given her verbal commands to place her hands behind her back. She was standing there with her arms still holding
I
her.
would object to any hearsay coming in for things that Officer Sanchez was directing Ms. Emerson to not present in court, and they would be an out-of-court statement being inserted for the truth of what he was telling her.
Well, the statements, I would agree, objection sustained, but what this officer observed another officer do, she could testify to that.
Certainly, Judge, just the statement.
Yes.
Thank you.
Can you again explain what you did what you did with the defendant?
Yeah, so she was advised that she was going to be placed in handcuffs. I told her to relax because she had her hands in front of her.
I'm sorry, to stop you there. Did you advise her that she was going to be placed in handcuffs?
I did not, not initially, no.
President, I again would renew my objection to any statements that another officer gave my comment. As it is a resisting, so any order would be asserted for the truth of what she's actually doing.
I'm sorry, counsel, please keep your voice up.
I apologize. Any statements another officer is telling her would be for the truth of the matter specific.
Oh, I said objection sustained. I'm sorry, wait. Okay, so next question.
What was your role in detaining the defendant?
So I instructed Miss Emerson to relax her arm. She had stated out loud to me that she does not like cuffs and she did not want to get placed in handcuffs. Again, she was instructed to place her arms, I'm sorry, I did not instruct her to do that. I instructed her to relax. She did not, she had her arms tense in front of her. So I grabbed her right arm with both of my hands and I moved it to the back of her.
Were you able to get the defendant to the police car?
So I instructed her to walk to the car. She stated she would not go. She doesn't want to go. I instructed her that if she doesn't go, she would be carried. And that's when her legs went limp and she refused to walk to the car.
What did you have to do to get the individual to the car?
I grabbed her under her arm and I helped carry with other officers assisting her to the vehicle.
And did the defendant eventually get into the vehicle?
Yes.
criminal name. When you got to the location, what were you wearing on scene?
I was in full uniform.
Was your partner in full uniform?
Yes.
And what did you arrive in? Was the vehicle fully marked?
Yes, we had a fully marked scout car.
No further questions, Your Honor.
Cross?
Good morning, officer. You mentioned on direct when you arrived, your understanding was you were responding to an assault,
Yes.
and it was regarding court the next day.
Repeat that, I'm sorry.
And the assault was an argument over court the following day?
I do not remember that.
Okay. Do you remember Ms. Amerson's social worker being called?
I do not remember that.
Do you remember her having a mental health social worker? No. And as part of your training, or when you arrived, it seems that Ms. Amerson was in a mental health crisis.
Possibly, it's not the very first initial thing that I was aware of.
You are trained how to deal with people who are in a mental health crisis, correct?
Correct.
That's part of your training you undergo to be an officer?
Correct.
And there's actually an additional training that's pretty recent that teaches officers how to deal with people who are in a mental health crisis, right?
Yes, but I didn't take that yet.
Right. But you could call officers who had gone through that training,
Yes.
the crisis intervention team.
Yes.
And they undergo 40 hours of training about how to deal with people who are in a crisis.
Correct.
And you didn't call that team?
No.
You didn't ask for their assistance?
No.
You just immediately went in to detain Ms. Amerson?
So I was not the primary unit, I was a assisting unit.
Right, but you did not.
I did not.
You went straight to detain Ms. Amerson?
Yes.
Okay. Now, you told her she was being arrested?
I do not believe that I was the initial officer that told her that statement.
Okay. So you didn't tell her that she was actually being arrested? Yourself?
Not initially, no.
Okay. You just told her she was being put in handcuffs?
Correct.
Do you remember her saying she was scared of going back to the mental hospital?
I remember her saying that she doesn't like cuffs. She repeated, I don't like handcuffs, I don't like handcuffs.
But nothing about going to a mental hospital?
I don't remember that right now.
And you grabbed her arms, right?
Her right arm, yes.
Her right arm, and you cuffed her?
I assisted another officer cuffing her arm, yes.
Okay, so you just grabbed her arm?
Yes.
Okay. Did she appear panicked?
Yes.
And she appeared scared?
Yes.
And was she crying?
I don't remember if she was crying.
She tensed her arms.
Yes.
And then while she was walking to the squad car, she got limp.
Yes.
And you picked up one arm?
Yes.
Okay. Now, she didn't at any point hit you, right?
No.
She didn't kick you, correct?
Correct.
She didn't bite you?
No.
She didn't spit on you?
No.
She just went limp, right?
Yeah, she refused to make any effort to walk to the vehicle.
And then she ultimately was able to get into the car on her own.
Once we got to the vehicle, I remember I stood her up and I searched her to make sure she had nothing on her, and she did sit in the car with us.
And then she had to actually be taken to Detroit Receiving Hospital at that point.
Yes, she had complained about previous pain from something else. That's the reason that she was taken to the hospital.
No further questions.
And you redirect.
No, Your Honor.
Thank you. Officer Lawson, you're all set. Thank you so much.
Thank you.
Any further witnesses?
No, Your Honor.
Pardon?
No further witness.
Madam Defense, any witnesses?
No, ma'am.
Is there a motion?
Your Honor, the people move to bind over on count 2 and 3 and reserve argument for rebuttal.
You're moving to bind over on count 3?
On count 2 and 3 because of the 2 officers that are listed here.
I'm sorry?
Count 2 and 3 because of the 2 officers that are listed here.
I didn't really hear the last part, but I think I get the gist of what you're saying. But we only heard from one officer, you know that.
Yes, Your Honor. But she testified that she showed up with her partner to arrest the individual.
Response?
Yes, Your Honor.
Do
Your Honor, ignoring the felonious assault because the people are not trying to bind over on that. I would next turn to the third count of resisting and obstructing where the officer was not present. We didn't actually hear any directions that the officer was giving Ms. Amerson in order to know that she actually resisted obstruction or obstructed or did anything to counteract what that officer was directing her to do. We didn't actually hear any physical way that that officer was resisted or obstructed. This officer only talked about her actions of trying to put handcuffs on one arm and then her actions of lifting one leg, but we never actually heard anything that Officer Sanchez did. The only thing that we know is he was physically present, but for all we know, he was just standing off to the side and there was no actions whatsoever. And then, Judge, to the remaining count of resisting and obstructing, I would just note that the term knowingly or willfully is the key term here that I think is in question. To convict a defendant of resisting or obstructing a police officer under this statute, the prosecution must show that the defendant assaulted, battered, wounded, resisted, obstructed, opposed, or endangered a police officer, and that they had reason to know the person was a police officer in their line of their duties. And Judge, I would point you to People v. Crawford, which is actually a fairly recent case, and the mens rea was the issue in that case. There was the question of what the defendant actually meant was presented by the state. In that case, there was some pulling, there was some falling down, and there was some spitting, and the question at issue was how much that behavior was repeated. And what we heard in this case was that Ms. Amerson said she was scared. There is an issue of whether or not she was undergoing a mental health crisis that this officer is trained to know how to deal with, and that she simply went limp while walking. We know that there wasn't, we also didn't hear that she was repeatedly told to stand up either while she fell, Judge. And so we don't know if she just fell out while she was undergoing a mental health crisis or if that was an actual act of resistance. And we do know that by the time she got to the car, she was able to stand up. We know there was no hitting, no kicking, no spitting, no saying, I'm not going. She actually got in the car at the end of this. And if you're looking at the Crawford case, along with People v. Potter, just out of May of 2021, you have to see that there is repeated intentional actions on behalf of the defendant for it to actually be a resisting or an obstruction. They have to show that it is knowing and that it is willful. And that hasn't happened in this case, Judge. And so I would ask that it be found over on no counts and that this case be dismissed.
Thank you. Your response? In fact, I don't even recall the name Officer Sanchez being mentioned. I just heard partner. Go ahead, your response.
Your Honor, Officer Latu testified to the defendant resisting. The defendant showed up with the other officer in full uniform, and when they both tried to arrest her, the defendant resisted by refusing handcuffs, and she also refused to get into the car because her body went limp. The people believe that there is probable cause for count 2 and 3 for resisting arrest.
Thank you. So obviously count 1 is going to fail because there was no complaining witness that testified by the name of Ulysses Washington regarding the felonious assault. So that matter is going to be dismissed without prejudice. Keep in mind, Ms. Amerson, that trailer language after the word dismissal without prejudice means that it is possible that that can be reissued. If you have questions about the parameters of that, please make sure you speak to your attorney so that she can explain that in greater detail. As it relates to count 2, the court is going to bind over. This is not a conviction. This is a probable cause hearing. So the burden of proof does rise significantly beyond here, and the prosecutor will be held to a much higher standard at that point. But at this phase, the prosecution has presented sufficient basis to meet the probable cause standard. So I am going to bind over as charged on count 2. Count 3 is going to fail again, while Officer Lucky testified as it relates to her involvement with the defendant. There was no testimony offered as it relates to Officer Sanchez. In fact, I don't recall that name was even placed on the record. She indicated she was working in tandem with a partner, but that was about it.
She also indicated that there were other officers on the scene. So for that reason, I don't know, I haven't heard any testimony on the record that would allow me to bind over on count 3. So counts 1 and 3 will be dismissed without prejudice, and count 2 is going to proceed to circuit for further proceedings with an AOI date of August 3rd at 9 a.m. Madam Defense, I do need your signature on this order of dismissal as it relates to counts 1 and 3.
You all put it down?
Yes.
Madam Defense, may I have the P number again?
Yes, ma'am, it's 85191.
Do I have all of the parties now on Mr. Young?
Ready?
Yes, Judge.
Yes.
Sorry, yes, Tammy, my apologies.
I need the prosecutor.
I am
Mr.
here.
Postum is here.
Okay. Calling parties on Young, case number 2058793. The people of the state of Michigan versus Demetrius Dewan Young. The defendant charged with count 1, homicide, murder, first degree premeditated. Count 2, 3, and 4, assault with intent to murder. Count 5, 6, and 7, weapons, felony, firearm. Count 8, weapons, felony, firearm. Judge, this is scheduled for a court date. They would like to ask for a competency hearing.
Thank you. Appearances, please.
Good morning, Your Honor. Jonathan Postema on behalf of the people.
Good morning, Judge. Patrick Nineheist, P76343 on behalf of Mr. Young, and I ask that we waive his presence. He's in the Wayne County Jail, and I also have Miss Gray here as well, who can provide a little bit of information on Mr. Young.
Good morning. For the record, Cena Cobra Gray appearing on behalf of Mr. Young, who is not present, and I too will agree to waive his presence, Judge.
Okay, who's representing Mr. Young?
So, Judge, it's Miss Gray is going to substitute me out, but because we're in the middle of a preliminary examination, she can't do it till the conclusion of that hearing. But she did get hired to represent Mr. Young, so she ended up talking to him and bringing it to my attention that he needs a mental evaluation. I thought maybe it was just because when we talked on Zoom, he was not good at Zoom, but after she talked to him, she came to the conclusion, and maybe she'll be better at explaining it, that she realizes he needs a mental health evaluation.
At this particular juncture?
Judge, would you like me to make the record?
Sure, but if you feel as though it's necessary that he be referred for competency, then you can make a record, but we'll refer him and give an adjournment for 90 days. But you certainly can go ahead and make a record if you like.
Judge, I'm satisfied with that.
Okay, can we have a 90-day review date?
Sure. Judge, would you refer him for competency and criminal responsibility?
Yes.
And
the waiver, Miranda waiver too, if possible, just to cover all the bases, Judge. Thank you very much.
And why is it that we couldn't get him present here via Zoom?
I sent paperwork to the jail yesterday, but he wasn't, when they got the paperwork, he was scheduled for an exam, I think next week, and we don't always have good luck of them making him available.
Okay, I will waive his presence for purposes of this proceeding. However, is he aware of what's going on? Does he have an understanding? Because
Judge, I'll make a record. On June 25th, 2021, I was retained by the family. On June the 29th, 2021, I conducted an attorney visit. And during that visit, I learned that Mr. Young has a history of mental health related issues. I learned that he has been receiving Social Security benefits for a disability since he was a child. As I began to speak with him regarding the circumstances of the case, he continued to indicate that he did not understand what was going on. On the 5th of July, I reached out to the family, had an office appointment with many members of his family, they confirmed that there was a mental health history. And the very next day I reached out to all the parties involved, and we agreed collectively that he needed to be referred for competency, criminal responsibility, as well as the ability to waive Miranda.
Okay, so this is not going to be news to him that there's been a referral for competency.
And they do understand, no, Your Honor, and they do understand that there, you know, the time issue with respect to the referral.
Okay, what's the 90 day?
October 13th.
October 13th at 8:30 via Zoom will be the competency review date. Also criminal responsibility. Madam Clerk, I do want to make sure that this gets referred properly. And voluntariness as it relates to Miranda as well. Was there anything further?
Judge, I just want to point out, we do have if you recall, this was the case where Your Honor bounded over and we didn't have the transcript for the bind over arguments. So I did submit 2 video statements from both defendants that were admitted at exam with the permission of the attorneys, and we were going to re-argue the bind over a week from, or 2 weeks from today. So obviously, Mr. Young will not be present for that date. Are we still proceeding with Mr. Moss Matthews?
Well, my impression is that we were, are we not? Are you wanting to pause on Matthews as well?
No, well, honestly, I would prefer to settle the competency issue in circuit court just for expediency's sake. I don't want either defendant sitting in jail any longer than they should be without a trial.
Are you asking me about Moss Matthews or Young? Young is paused and we're having a review October 13th. Are you asking about Moss Matthews now?
Well, I want to know what I need to be prepared to do on the 27th, Judge. That's.
Okay, I'm going to touch Moss Matthews' future date. Did you want to alter that so that the bind over, or so that we can handle this in tandem, or you let me know what your pleasure is, because I'm treating them as 2 completely separate individuals, even though I understand they're co-defendants.
We can go ahead on the 27th, Judge. That's fine. We'll just do that. My main issue was having them separate. We're just going to have to wait up in Third Circuit Court, but that's fine. We'll do that.
Well, okay, so I'm not saying I'm opposed to having them side by side. I just don't have, unless I'm mistaken, I don't think I have defense counsel here for Moss Matthews. Do I? I don't know, maybe I do.
It wasn't up today, Judge.
So if Mr. Postema, if you would like to have whomever that is, I don't have it right at my fingertips, whoever is counsel for Moss Matthews, zoom in. And, you know, so long as everybody's on the same page, I absolutely do see where it makes sense that they're side by side, given the procedural history here. So if you would like to, I just don't want to unilaterally affect it in the absence of Moss Matthews and Moss Matthews' attorney.
I understand, Your Honor. I'll reach out to defense counsel. And
defense counsel is John McWilliams.
Okay.
Just to let the court know.
Thank you, Mr. Nyheis. So yes, if you want to zoom in either later today or tomorrow, next week, or anytime, just let me know anytime before the 27th so that I know what I need to be prepared for on my end, because there is much for me to review to be prepared for the bind over argument if it is going to take place. Because again, that was a matter that that was brought back, and there's videos, as you know, that you've already dropped off. So I just want to make sure that I'm using my time properly and preparing if we are going to proceed on Moss Matthews. But again, I welcome you to have that attorney, get in touch with that attorney and zoom in, and we can alter the date if that's satisfactory to Mr. McWilliams.
I will reach out and talk to Mr. McWilliams, and I'll get back to the court. Thank you.
Okay. Appreciate that, thank you. And we've got a review date, competency review, October 13th at 8:30 via Zoom. If we get a report in advance of that date and you want to tee it up in advance of that date, I'm here for it.
Thank you, Judge.
And Judge, there's one other matter that I would like to address and put on the record and seek guidance from the court, if I may.
Yes.
Judge, so at the time that I was retained, I didn't realize that there was an issue with the proceedings being recorded by the court reporter. So I just like the court to know that my objective is to file an appearance if in fact there's a bind over, because I would not want to substitute in as counsel and could not in the middle of a preliminary examination that is in progress. But I will work diligently with co-counsel, the attorney of record. Absolutely, he is fantastic.
Okay.
And Ms. Gray's called me a bunch of times. We're working together on this until she's able to substitute me out, Judge.
Okay, no, that makes sense, and I do understand why the substitution hasn't occurred. I just didn't understand initially. Okay, so in the event that it is on the date that we pick back up and it is bound over, then I think that would be the more appropriate time. I would agree for there to be an actual substitution from Mr. Nyheis over to Ms. Gray. So I don't have any problem with the two of you working in tandem until that happens.
Judge, thank you. And there was one other thing. When I spoke with co-counsel, he was not in possession of the medical examiner's report. I would ask if the prosecutor would email that to the both of us, if possible.
Mr. Postema?
I'm happy to do that. I was not aware that he wasn't in possession of the ME report.
Thank you so much. I appreciate you.
Thank you, Mr. Postma. I think you might have given it to me, but I didn't scan it in, and then I wasn't able to provide it to Ms. Gray as a digital copy. So I appreciate that, Mr. Postma. Thank you.
Very well. I'll have that out in a few minutes.
Okay,
Thank you so much.
Judge, thank you.
You're welcome. We're all set here.
Calling parties on Smith, case number 2159002. Where's Mr. Bloomers? Right there. Oh, I can't see behind over this thing. The people of the state of Michigan versus Martell Samaj A. Smith. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. Habitual offender, 4th offense notice. This matter is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Eva Tkachik, P number 70002. I'm representing Mr. Martin Smith. Your Honor, I had a different date of the PCC. I'm sorry. I don't know where is Mr. Smith, whether he is present on the Zoom, whether he's in jail. I have discovered.
Hold on. Mr. Smith was there. I put him in a breakout, not a breakout, but the waiting room because he was sleeping.
Oh. Well, I was trying to contact him, send him letter, and I called. I need his phone number if the court allows.
Let's see if he's awake. Let's bring him in.
He called.
I know.
I'm not sure. I think he may still be taking a siesta. Nope, there he is. Okay. Could you state your name, Mr. Smith? You are muted. You could just tap that button. Your name once again, sir? Thank you, sir. Okay, today is the date and time set for PCC. Madam Defense has expressed an interest in wanting to have better contact information for you. So in just a moment, I'm going to put you in what's called the breakout room, and you can share each other's information. I just don't want that to be shared live on YouTube. But as it relates to the PCC, Madam Defense, what's your pleasure?
Your Honor, may I request short adjournment of the PCC that I will be able to make decision about exam, please?
August 13th? Are you available Friday, August 13th at 8:30 via Zoom?
I will check, Your Honor. Hold on for a moment, please.
or really any day that week that works better. Good morning, Mr. Chambers.
Morning,
August
Judge.
13 is good. August 13 is very good.
Okay, August 13th.
Yes.
I
can't sit up no more.
What's that from?
Okay, so I am going to, Mr. Bloomers, is there any concern regarding bond?
Yes, Your Honor. The bond as set currently is $10,000 personal bond with a no contact order. There was no tether in this case. I've reviewed the allegations and spoken to the complaining witness, LaTanya Strong. This is a domestic case. They have a child in common. It's a felonious assault with a knife. Mr. Smith is a habitual fourth offense. The complaining witness is extremely fearful of the defendant. She is also in the process of seeking PPO because she is very concerned about him trying to contact her in person. And after speaking with her, I've determined based on my conversation with her that a tether is in order to protect the safety of the complaining witness in the community. I think there was an abuse of discretion in not ordering one in this case when the bond was set by the magistrate. So people would move to modify the bond to add a GPS tether.
Have there been any violations since he was arraigned?
No.
Okay, so Madam Defense, I certainly am going to give you an opportunity to respond, but let me tell you, just right off the bat, that I do not like to manipulate, adjust any bonds that are set by the magistrates, but I'll do it when I feel as though they've abused their discretion, which unfortunately, Mr. Bloomers can tell you, I find myself in that predicament quite often. I'm not really certain the circumstances that are presented or what they're taking into consideration, but here, Madam Defense, we have a situation where an individual is charged with an assaultive offense, wherein the weapon that was alleged to have been used. Of course, they're just allegations, but that's all I can look at when I'm reviewing bond. But the alleged weapon here was a knife. And on top of that, this is an allegation of a domestic violence, which always gives way to a heightened temptation to want to reach out to the complaining witness because of that level of familiarity that was there or is there. And sometimes it's in a pleasant way, and sometimes it's in a not so pleasant way. So I say all of that to say, coupled with the fact that he's an habitual offender, fourth offense notice, those are all factors that are taken into consideration when determining whether or not the bond that the arraigning magistrate set was appropriate. And the bond here was set at $10,000 personal bond, so he didn't have to put up any money. And there was just a warning that an order that he have no contact with the complaining witness. Now that's all good and well, but when there's this familiarity here, when there is this familiarity between the defendant and the complaining witness to the level that it's marked as a domestic violence allegation, that causes concern. And it, I believe, was an abuse of discretion that the magistrate did not impose a GPS tether, which, as a matter of course, is quite often imposed. I see that your client is looking confused, and I would like for you to take an opportunity to go into a breakout room and perhaps explain, because if he's unfamiliar with the criminal justice system, perhaps he is not aware of the certain measures that the courts take while cases are pending. So I'm going to put you in a breakout room with him for two reasons. Number one, for you to talk to him about what I'm getting ready to do, which is to impose a GPS tether. And number two, so that you can exchange personal information so that you can get in touch with one another. And if you wouldn't mind, please come back so that we can talk about how he's going to get this GPS tether, okay?
I see. Yes, Your Honor. I would, if I can, I would like to object to imposing the tether. I review the discovery. There are no any injuries in this case. My client should not contact the complainant, that is for sure, and I'm going to explain it to him. But in many cases with tether with the defendants, when the court is closed and there are some costs to the tether, it is more than inconvenient, and we have a lot of struggle in the cases like that with tether. But obviously, I inform my client that he is not supposed to contact my victim directly or indirectly in any ways. Yes, I will be back on the record if it's necessary.
Yes, it is going to be necessary, and I appreciate your response. But again, I have reviewed the allegations, and what the court is not in a position to do is to take lightly what it has before on the bench here. And I have to look at that because the second prong of that bond analysis is so huge. The safety of the community at large, particularly the complaining witness, for which, let me just remind the record that Mr. Bloomers indicated that he's been in contact with the complaining witness, and the complaining witness is fearful. So I can't let those words fall on the record and me not respond to it. So if you could take a moment and please speak with your client, and I am going to prepare the order for the addition of a GPS tether.
I see. Yes, Your Honor, I will. Thank you.
And let me just also say this, because sometimes, I never know how someone's going to receive what I've just said. You do need to come back out of the breakout room, Mr. Smith, and join us. The order is going to be signed whether you come back on the record or not, and there will be a requirement. And if you fail to get that GPS tether attached and come back on the record and receive that information, then you're subject to be in a position where you're going to be picked up. So I just want to make sure that we're all on the same page and nobody's misunderstanding what's going on here. Mr. Postema, I see that you're still here, sir. Did we have another matter? Are you counsel with Mr. Chambers?
No, Judge. I did reach counsel for Moss Matthews on the case that was just called. So I wanted to let the court know what that conversation consisted of.
Yes.
So I did speak to Mr. McWilliams, and he said he would have no objection to tracking the young competency report evaluation. But he was I'm sorry.
Is there any way he can join us so that he can put that on the record?
Yeah, he was driving to an exam that was in progress, so he was not able to put that on the record. My thought was, we're up in 2 weeks anyway, maybe, and we know that's a good date for him, if he's willing to, and he told me I could speak for him here.
All right.
Maybe we could address it then with the knowledge that we aren't going to have a bind over argument that date.
Okay, so we'll need to make sure that, I would like Moss Matthews to be present. So maybe we will just have we'll just change it, Madam Clerk, from in-person to Zoom so that Moss Matthews can hear what's going on. I'm sure Mr. McWilliams is in touch with him, but I always like for individuals to hear what's going on, and we'll just address it then, Mr. Postema.
Thank you, Your Honor.
Okay, so again, just to be clear, the understanding is we're not proceeding with that bind over argument?
Correct.
And we're gonna have it tracked with the co-defendant. So I just want to make sure I'm prepared on my end for what to expect on the 27th.
Correct. I will send an email after I sign off, and I'll CC your court with Mr. McWilliams, just confirming and making sure everyone's on the same page.
Thank you. I appreciate your organization in that regard, Mr. Postema. Have a great day.
Thank you. You too, Your Honor.
Thank you. Okay, Mr. Harris and Mr. Chambers.
Miss Bruder just signed on. I'm gonna call. Calling parties on Wright, case number 2058001. The people of the state of Michigan versus Trey Leonard Wright. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. The defendant is also charged in case number 2058140. The people of the state of Michigan versus Trey Leonard Wright. The defendant is charged with count 1 and 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, assault with a dangerous weapon, felonious assault. Count 4 and 5, child abuse, second degree. Count 6, malicious destruction of personal property, $200 or more, but less than $1,000. Judge, this is scheduled for a preliminary exam tomorrow afternoon.
Thank you. Appearances, please.
May it please the court, Mary Ann Bruder on behalf of the people, P55239. I'm on both files, Your Honor.
Thank you.
Good morning, Your Honor. Arnie Chambers on behalf of Trey Wright on both cases, P63956.
Thank you. Okay, what are we doing here in advance of the exam date?
Judge, as I've indicated to Madam Prosecutor and this honorable court, I have a homegoing service to attend tomorrow. So obviously this is unexpected. And I'm not going to be able to appear on behalf of Trey Wright. So we're asking for an adjournment. I don't believe there's going to be an objection from the people. I've communicated this to them, and I mean, they can speak for themselves. But if the court would oblige, I'd ask for a court-ordered or adjournment of tomorrow's preliminary examination.
Okay, certainly. Madam Prosecutor, would you care to be heard?
Your Honor, just two things. I am sorry to hear about Mr. Chambers' loss, and the people do not object. Obviously, emergencies come up. I would never object to a request for an adjournment under these circumstances, Your Honor. And I did want to put on the record that I did provide Mr. Chambers. He's asked, the court may recall 2 hearings ago, we had an issue where the witnesses didn't appear because one of the gentlemen was in the hospital. I did provide some documentation to Mr. Chambers via email to show that that in fact was true, just so the court is aware.
Oh, thank you for that notation. So we're going to adjourn this matter. What date, Madam Clerk? Is this in custody or non-custody?
He's out of custody, Judge, and he's aware that there's going to be an adjournment, and he has no issues with that.
Okay, so you're requesting to waive his presence for purposes of scheduling here?
Yeah, yes, I am, Judge, and I've spoken with him as late as midnight last night with regards to this.
Okay.
There are about.
Can we find a date in September?
Do we need an afternoon?
Preferably, do we have one?
Oh, we have lots in.
Oh, okay,
afternoons
like
in
early
September.
September, given the nature of the allegations.
September 2nd at 1:30?
If I could just check. That is fine for the people in the afternoon on September 2nd.
Yes, sir. Yes, ma'am. Mr. Chambers?
We'll make it happen, Judge. I do have, so the court knows I do have a final conference that day in circuit court that would be held over Zoom. So that starts at 1 o'clock.
Well,
but we'll make that sure we can.
What about the 3rd?
I just hate Fridays coming into that time of the year.
Okay.
How about August 30th?
Yeah, if we have, I have a prelim scheduled at 1 o'clock that should not take long in front of Judge King, so I can come immediately after that.
Okay, would you rather the 2nd or August 30th?
No, the 30th, please.
Okay, August 30th.
Your Honor, my only concern, I don't know how many cases Judge King sets in the afternoon, and the court may recall we waited a long time on this case, and I do have minors that are witnesses. That's my only concern. I mean, I understand Mr. Chambers' schedule. I can do either day, but I don't know if Judge King schedules more than one, and then he gets pushed behind.
September 7th at 1:30?
That works for me.
Perfect. Thank you, Madam Prosecutor, for bringing that. September 7th, are you available?
I have an exam with you in the morning, so I guess I'll have an exam with you in the afternoon as well.
Fantastic. All right, September 7th at 1:30 for live exam. We're setting both of these at that time.
Yes, Your Honor.
Anything further?
No, Your Honor.
No, that's it, Judge. Thank you.
Thank you.
Judge, before you
And
recall
condolences to you, Mr. Chambers.
Yep, I
Mr.
appreciate
Harris,
it.
Mr. Harris, what case are you on?
Yeah, they called me this morning for a spot assignment in your court.
Oh, okay. On Savage?
Yeah, Savage is the name.
Okay. That's your case, isn't it? Ms. Shaku's is not there. What did you want to do this morning?
Well, I just got appointed, so I'm gonna have to set it for another PCC or preliminary exam, whatever the court wants to do.
Does August 12th work for you?
Let me see. I think that is fine.
Okay, you're all set then.
Yeah, August 12th is good.
Madam Defense, on Smith, is your client here?
He may still be in breakout room, Your Honor.
I haven't talked to him.
We're ready.
Yeah. Okay.
Madam Clerk, am I supposed to stay on or what's the situation?
No, you're all set.
August 12th. Okay, Savage. Okay,
All right.
thank you.
So
Take care, Mr. Harris.
can I
Take
call Connors?
Yes.
Oh, there he's back now. Calling parties on Connor, case number 21-56618. The people of the state of Michigan versus YYYYMMDD Connor. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence, commission of a felony with a motor vehicle advisory. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people. Judge Archer, good morning to you, to your staff, good morning. Michael Woodyard, P 64612. I'm appearing on behalf of my client, Navia Connor.
Okay, is your client here?
Your Honor, it appears she is not. I will tell the court that I had contact with Ms. Connor early on in this process. This matter has been pending for several months now, as the court knows. When I reached out to her by my previously operable telephone number yesterday, a strange person answered the phone and said, I've got this number about a month ago and I don't know who you're talking to or about. So that's my explanation, Judge. I wish you were here because it looks like the witness is not here. So I have a feeling what you're going to do, but I don't have any explanation.
Is there a motion?
Yes, Your Honor, the people move for habeas.
Okay, it is currently 10:22 in the morning. This matter was set for an examination at what time?
10 a.m.
10 a.m. and the defendant has failed to join the party here, and that's unfortunate. This is being an exam date. The defendant was placed on a $100,000 personal bond. It does not appear that there was a GPS tether imposed, but her failure to appear here this morning is problematic, and I am going to grant that motion for habeas. Previous bond is going to be revoked. Defendant's new bond is going to be set at $50,000 cash or surety. Is there further?
Nothing from people, Judge.
No, Judge.
In the event that you are able to get in contact with your client, you certainly, if it is today, you can certainly either walk her in or Zoom in. But after probably 3 o'clock is when it's usually entered. After the capias is entered, then she will have to avail herself in the normal course of an individual who has an open warrant. But if she's able to get on Zoom at the very least, then I will allow you to make a motion regarding the status of the prosecution's inability to proceed.
Your Honor, I appreciate that consideration. Thank you.
Thank you.
Thank you, Judge.
You and your staff have a great day.
You too.
Thank you.
Pleasure to see you.
You too, Judge, as always. Your Honor, may I approach you very briefly?
Yes, sir.
On unrelated matter?
Yes, sir. Yes, sir. I see that Mr. Smith is back here. Mr. Bloomers?
Mr. Smith was your case, correct?
Oh, yeah, yep.
Okay, this is a recall of People versus Martell Smith, 210590002. Can I have appearances again, please?
Jacob Bloomers on behalf of People.
Iva Tkaczyk on behalf of Mr. Martell Smith. I talked to my client, I got the information. We asked the court to set the date for the exam in person instead of the PCC on August 13. And we talk about the tether. My client claims that he did not contact the victim. The victim is texting to him. So I will ask the prosecutor to advise the complainant not to communicate with the defendant in any ways. So
I encourage the prosecutor to have that conversation, but here's the tricky part, which I know you've explained to your client. The complaining witness doesn't have a bond on her. Mr. Smith does. Now, again, certainly the complaining witness should not be gaslighting, stirring the pot, or even just contacting Mr. Smith, even in a pleasant way. But Mr. Smith is the one that has a bond that is going to be affected by that contact. Even if the complaining witness comes to your doorstep, yeah, I know, I can see by the look on your face that that's shocking. But even if and I don't know what happens at the arraignment, but I fear that people aren't being thoroughly explained the parameters of no contact. No contact really just means exactly what it says. Even if, I'm going to state it again, even if the complaining witness comes knocking at your front door, you are still not permitted to engage with her.
Excuse me, Your Honor.
Yeah.
If the complaining witness can confront me with the emergency doing like love matters or whatever, like, and just to throughout the love or whatever, like, then, you know, like, what are you supposed to do in that instance? Still not have no contact with her?
I can't say that I really understand what you're saying. Can you repeat it for the record?
I'm saying I was approached by the complaining witness with an emergency, and I was getting texts and all kinds of things in the instance of she having some type of emergency. So I mean, okay. I don't know what.
I will say this: the record is not going to be very clear here because your audio is a little muffled. But if I'm hearing you correct, even under those circumstances, no contact means no contact. So I suppose your attorney should explain to you, but if someone comes to your door, particularly the complaining witness, comes to your door, you have to not open the door. And if she calls you, I don't know if you're talking to me because you're muted, but if she calls you or texts you, we can't both talk at the same time. So that's number one. If she calls you or texts you, you have to hang up. And if you have any question about anything that's confusing about that, please make sure you talk to your attorney because it is your bond that's going to be yanked if there's contact. Okay, so I am going to impose a GPS tether. I've written up the order. Counsel, you're going to be forwarded a copy of this. Madam Clerk, what are the instructions? He goes to DDC or?
I'll give him a phone number to call. He can call the tethered unit. I'll notify them, but then he can also call them and they can give him
Can you include that number on this form that you're forwarding to Madam Defense as well?
Yep, I will.
So, and let me just be a little bit clearer about this. Adding the GPS tether is not optional. Like you don't have the option to say, I heard what the judge said and I'll get to it when I can get to it. This is an order of the court, and the expectation is that you are going to comply immediately. And counsel, I'm going to ask you to explain that to him, just in case there's any gray area on that. And with that, please keep in mind that no contact provision still is in place. We need to set an exam date. We'll disregard the new PCC date of August 13th. Can we set it for an exam on August 13th?
Yes, Your Honor. Yes.
I guess.
Or
the 27th would be better.
August 27th is going to be the exam date.
At 10 a.m.
At 10 a.m.
10 a.m. Let me check the date, please. August 27 is not good. I am in the exam.
Okay. What's the next best we can do?
Can you do August 24th at 10 a.m.?
Yes, I can.
Okay, there it is, August 24th at 10 a.m., which is much sooner than many other dates that people are given. So that's as soon as we can give. And we're going to forward that order for the GPS tether along with the information, the number to call, and we're all set.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Anybody check in on Johnson?
No, not yet.
No?
But witnesses here. Here. No attorney, no defendant.
Officer, Mr. Bloomers? You said that the defendant is here on Johnson, but
No,
not counsel.
No,
Just the
witness is here on Johnson.
Okay. If I could trouble you, I need to know precisely when they get here.
Sure.
Good morning, Mr. Quinn.
Good morning, how you doing?
Calling parties on Johnson, case number 2060217. The people of the state of Michigan versus Wolfie Johnson. The defendant is charged with count 3, assault with a dangerous weapon, felonious assault. Count 4, assault with a dangerous weapon, felonious assault. This matter is scheduled for preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Christopher Quinn, appearing on behalf of Ms. Johnson, who is present.
Please state your name.
Wolfie Johnson.
Thank you. And Mr. Quinn, can I have your P number for Madam Court Reporter, please?
69483.
Thank you. All right, we're here today for an examination. Are we proceeding to an exam?
People are ready to proceed.
Okay, how many witnesses?
Just the one, Judge.
Okay, let's go. First witness, is there anything preliminarily or?
No preliminary matters to the people.
Okay, first witness.
Your Honor, the people call Tina McFarley.
Good morning to you. Please state your name for the record and spell your first and last name.
Tina McFarley, MCFOLLEY.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. If you make your way over here, oh, yes.
May I have the spelling of your first name, please? TINA.
Thank you. Thank you. If you could make your way over here, this little half gate will open up towards you and have a seat and your witness once she's settled.
Good morning, Ms. McFarley. Could you please state your full name for the record?
Tina McFarley.
Okay. And Ms. McFarley, on or about the date of July 31st, 2020, were you at or near the address of 10100 Harper?
Yes.
And is that in the city of Detroit County?
Yes.
And how do you know that address?
The kid's father was staying there at the halfway house.
And you say his father, who's that?
The kid's father.
Oh, the kid's father. Okay. Is that your child?
My 2 younger sons.
Okay. And was anyone else at that location that day with you?
Yeah, Miss Johnson,
Anyone else?
Robert, and a girl. It was a few people.
Okay. So, first I'm gonna ask you, just when you say Robert, who is that?
Robert Ambrose, that's the kid's father.
Okay. That you have children in common with?
2 little boys.
Okay, thank you. And you said Ms. Johnson, is that Whoopi Johnson?
Yes.
Do you see Ms. Johnson here in the courtroom today?
Over in the bench area.
Could you just describe what she's wearing and just point her out so that the judge can see?
She has on red and black and curly hair.
Okay. Let the record show the witness identify the person, the defendant.
The record will reflect identification of the defendant.
Okay. So you said at this location, you were there, Mr. Ambrose is there, Ms. Johnson is there, and then one other female who you can't identify? Okay.
What was your response?
No.
Thank you.
Well, I'm sorry, the no is to the identification or to that?
To identifying the female.
But otherwise, the other people were there? Okay, sorry. So what were you doing there that day?
I was coming to see the kid's dad.
Okay, and why were you doing that?
For personal reasons, he's supposed to give me some money or a lot of stuff going on.
Okay. And so when you arrived at that location, did you meet up with Mr. Ambrose?
Yeah.
Okay.
He came.
Is that a yes?
Yes.
And so when you met up with Mr. Ambrose, what happened?
He told me he was talking to his cousin Dominique in the car.
Okay. And after he told you that, what happened next?
It wasn't Dominique, it was a girl.
Okay.
2 girls, 2 females.
And were any of those, and
Whoopi Johnson and a girl did that.
Thank you. And so you see these 2 individual females in the car and you're talking to Mr. Ambrose, what happens next?
Well, he said that it was his
I'm
cousin.
objecting to this testimony.
So without telling me what Mr. Ambrose said,
Okay.
just tell me, you're speaking with Mr. Ambrose, correct?
Yeah.
Okay. And you see, as you testified, you saw the two individuals in the car, one of whom was Ms. Johnson. So what?
Yes.
And yeah, important to make sure that you answer with a yes or no question, or yes or no, as opposed to just or shaking your head, okay?
Yes.
So what happens after you're talking with him? What happens next, without telling me what he says?
Well, once I realized that it wasn't cousin, the girls come up to and they ask him, who is she? Who is she? Who is she?
Okay, I'm gonna stop you just there real quick. When you say come up to you, is that on foot or in the car?
No, it was on foot. We was like at the sidewalk.
Okay, so they got out of the car?
Yeah.
Okay. So they're asking, who is she?
Mm-hmm.
Okay, and what happens next?
And I'm backing up and he kind of tells them like that's mine.
Objection, hearsay.
Objection sustained.
That's okay, just remember, don't tell me anything Mr. Ambrose said. Anything.
Oh, well, I was backing up and as I'm backing up, the girl, she pulled the mace, she sprayed the mace.
Okay, I'm gonna stop you there. You say she, who's that?
Whoopi pulled the mace.
Okay.
She sprayed the mace. As I'm turning, because he's trying to catch the girl with the bat, and I'm turning and I take off running.
Okay, so I'm gonna stop you there. Okay, so we just proceed a little bit at a time to make sure we understand what's happening, okay? So you saw the two females approach, one of whom was Ms. Johnson. About how far away are they from you when she says she pulled out the mace?
We were all in distance. We were all on the sidewalk. We were all in distance of each other. My back is this way.
Okay, so.
They're approaching.
All right, so you say she pulled out the mace. What did she do with the mace?
She went to spray it, and as I turned around to run, the other girl, she lifted the bat, and he pulled in his arm so she won't, hit me with the bat, and I take off running to the back of the field.
Okay, and the individual with the bat, that's the one you can't identify?
Yes.
Okay. So did she spray the mace, do you recall?
Yeah, she sprayed the mace as I was taking off running, and the girl in the sequence, she trying to hit me with the bat, and she spraying mace. As she spraying mace, the girl lifted the bat to hit me, with the bat, and I take off running.
Okay, so after you take off running, where do you go?
I run all the way to the back.
The back?
It was like a fence, or it's trees, it's debris. I'm running like back here.
Okay, so is this the back of the?
Cadillac.
Okay.
The halfway house.
Okay. So you run into the back, like the backyard?
There was nowhere else for me to go, so I had to turn around, and as I'm coming back, it was already, going across to their cars. And as I'm coming back up, that's when she approached me with the car, and I had to climb the street in order for her not to hit me with the car.
So I'm gonna stop you there. So I just want to clarify though, so you say you ran in the back of this halfway house, and so is that like a backyard area?
It was like a field. It's a field.
All right, so you run into this field area, and what happens as you're running into the field?
They were chasing me.
Okay.
I guess I'm running so far, and I run, so far back. Ain't nothing but trees and debris, so I had no way but to come back this way.
Okay, so they're chasing you, and
Who's that? Whoopi Johnson and the girl with the bat.
Is Mr. Ambrose chasing you as well?
Yeah.
Okay. So what happens next?
I go back so far, and as I'm going back, I'm ahead of them because I'm running. I took off running once they trying to, once she sprayed the mace, once the girl, lifted back to swing, I take off running. Once I run so far back, it's nothing but trees and debris, so I had no choice but to come back and run, come back forward. As I'm coming forward, it's a big tree. By that time, they're in their cars.
Okay, so I'm gonna stop you there. So you say, basically, you ran away as you're coming back. You see them, that you say they're in their car. Who's in the car?
Whoopi Johnson, she in her car, and the other girl in her car. They both in their cars.
They're both in separate cars?
Yeah, in two different cars.
Okay, so they're each driving a separate car?
They're both driving a separate car.
Okay, so you turn around, you see this, what do you see next?
Her approaching me in the car to where I had to climb in a tree for this girl not to hit me with her car.
Who is her?
Whoopi Johnson.
Thank you.
Whoopi not to hit me with her car, I had to climb in a tree.
Okay. Was she coming at you slowly, quickly?
Full speed.
Okay.
She was coming, as I was coming this way. Luckily, it was a tree for me to climb in for her not to hit me with her car.
Okay, and do you recall, did she strike the tree with the car? Or?
No, she did not strike the tree with the car or the tree. And then the other girl took off and stabbed White Rob.
Okay. So What were you thinking as you saw her approach with the
That she
car?
was gonna kill me.
Okay. After you climb the tree, what happens next?
They take off. Once she can't hit me, she take off about her business.
And that's Ms. Johnson? Okay.
And Whoopi take off. She take off in the car.
Okay, and what about Mr. Ambrose and the other individual?
He stayed there, that's what he lived. So he was just standing out. We just standing outside, standing around, arguing about these two girls trying to jump on me.
Okay.
So I get over the car.
Did the other female leave after that?
Yep,
Okay.
she left. Both of them left.
And what did you do after they left?
Waited on a ride. I stayed there arguing with my baby daddy about two girls trying to attack me. Why they trying to attack me?
Okay. Did you call the police?
Yep.
Okay.
Is that a yes?
Yes.
Thank you.
And did the police respond to the scene and talk to you?
They didn't come when I was there.
Okay.
I had to go into the precinct.
Okay. No more questions.
Cross-examination.
Mr. Foley, prior to July 13th, did you know Miss Johnson?
Prior to the, no, I didn't.
Okay. So you had no interactions with her
No,
prior to that? Okay.
No.
And so what time of day was it on the 13th?
it was at night.
It was at night? Okay, what time?
I don't know the exact time. I can't remember the exact time. It was dark outside.
And so you said you were just coming up there for personal reasons, particularly you mentioned something about money and getting that from Mr. Ambrose, is that correct?
Yes.
So were you in a pleasant mood at this time?
Was I in a pleasant mood?
Yeah, were you happy to be seeing Mr. Ambrose that day?
I'm normal. I don't know. I don't.
So there was no
yes.
tension, there was no tension?
It was no intent.
No tension. Everybody was
tension.
happy. Yeah, you and Mr. Ambrose were happy. I mean,
Yeah.
he was happy to see you. You told him you were coming up there, correct?
He knew that I was coming.
No, you told him you were coming up there. You told
Did
him.
I tell him?
Yes.
We agreed. He knew that I come. I come there often.
I know. When did you contact him that day?
Did I contact that day?
That you told him you were coming up there?
Probably maybe all day.
No,
Talking, texting.
Oh, you
Yes.
had texted him several times?
Yes, we talked.
Oh.
He knew I was coming. We spoke.
Oh, you spoke? Okay, that day.
Yes.
Okay, you told him that you were coming that evening. What time was it?
I didn't have a certain time to arrive.
No, I'm asking you what time was it?
I don't know what time it was.
You
It
said
was
it-
dark outside.
You said it was dark outside. It was nighttime.
It was night.
Okay. And this was in July, so it gets dark later. So it'd have to be after 9 o'clock?
I'm not sure. It was dark outside.
Okay.
I can't remember the time.
Okay, so you would agree that it's after 9 o'clock?
I can't agree on what time it was. It was dark outside.
Okay, so you told him you were coming that night?
I did not have a set time to when I was seeing Robert Ambrose.
Oh, okay, so you never told him that you were coming at night?
It's not about me telling them, it just wasn't a certain time of me
No.
arriving.
No,
to
I'm asking you a
be
specific
there.
question. Okay, I'm asking you a specific question. You never told Mr. Ambrose that you would be arriving in the evening, is that correct?
Well, there was not a specific time for me to tell him my arrival.
Okay, so you never told him. Now, so when Mr. Ambrose saw him, your purpose was to get money from him, is that correct?
Have a conversation, get money. I mean, that's my kid's dad.
Okay, and so when you see Mr. Ambrose and you see him talking to, you said two people in a car, is that the time you asked him for the money?
I never seen him talking to two people in the car. He told me that he was talking to his cousin Dominique
Right,
in the car.
I understand, but you looked in the car and you saw there were people in the car, correct?
No, I didn't look. The car just looked similar to his cousin
Oh,
Dominique.
so I just so I'm clear, you never even had interaction with the people in the car?
Did I ever have interaction
Right.
with the people in the car?
No.
He said that was Dominique, his cousin.
Right, so you had no interaction with them?
No, she
Okay.
wanted to know, I had interaction with the girls when they approached me asking who I was, spraying mace.
All right, I'm saying, but when you arrived at the scene, the first person you had contact with was Mr. Ambrose,
Right.
correct? And he informed you of who he was speaking with.
He's talking to Dominique.
He informed you who he was speaking with, correct?
Mhm.
And at no point did you look in the car to see if that was true or try to verify that or anything, right?
It looked like Dominique's car. I had no, it's Dominique's car.
Right, so you never even looked in the car.
No.
So when he told you that, and after you asked him about that, is that when you asked him for the money?
No, we were just having a conversation. We were just talking. He knew that I was there. Like it was so much going on.
Okay, so you talking, So he sees you. Is Mr. Ambrose, once he sees you and he tells you that this is Dominique that he's speaking with, does he seem pleasant and happy?
I'm not understanding. He didn't seem no kind of way. He didn't seem upset.
Oh, he didn't seem
like we had a
upset.
problem.
And you weren't upset, correct?
No, we never had an issue.
Okay, so at that point, then you find out that it looks like Dominique. He tells you it's Dominique. There's no issues. So then, do you then ask him for the money?
We sitting there having a conversation. We just talking.
Okay.
I wasn't even 5 minutes there.
Oh, so how long?
It wasn't even 10 minutes there. It wasn't a long time that I was there.
Okay, so how long was the conversation between you and Mr. Ambrose?
It was a short conversation.
Okay, and at no
because
point.
all the drama started to happen. It's like simultaneously all this going on.
I got you. But at no point did you have conversation with whoever, Dominique or whoever was in that car, right?
I don't know. Dominique never had a conversation with Dominique. It wasn't Dominique.
I got you. Or anyone in that car.
Yeah, when she approached me.
No, but you never approached that car to have any exchange any words with them.
It was the car.
Objection has been answered.
She's not answering the question. She's avoiding the question.
I believe that she said she did not talk to anyone while they were in the car.
That's not what she
approached the
said.
car multiple times now.
That's not what she said.
That is what she said, but let's just once and for all get the question answered for the 4th or 5th time. Ask it again.
You did not approach the car, correct?
No.
You did not have any conversation with anyone in that car, correct? While they were in the car? While they were in the car? No. Okay, so there was no tension between, at the time, between you, the individuals in that car, and yourself, correct?
Well,
there was no
how can she
dispute.
answer that question?
Huh?
How can she answer if there was tension from the individual?
No, I'm saying,
towards her?
did you have a dispute with anyone in that car prior to the incident?
Not until she maced me and the girl with the bat, she won the bet. That's when the tension came in. Before that, I do not know this girl. Never had a problem with her.
Right, so what I'm trying to get to.
She caused the problem.
I got you. So what I'm trying to get to is, you're saying that unprovoked, Ms. Johnson.
I never did any harm to this girl, but this girl sprayed me with no mace. This is what I'm telling the court. I ain't do no harm to nobody. I did not do any harm for her to spray me with mace or for that girl.
And the question is now, has been answered. Wait, did you hear her response?
No, because she didn't let me finish the question. She did not let me finish the question. You, unprovoked, Ms. Johnson and this unidentified woman jumps out the car, correct?
It was unprovoked for that girl to spray me with mace and for that girl to hit it. Yes, it's unprovoked.
Okay, thank you.
For her to spray, it was unprovoked for her to spray
No, I just
mace.
asked you about her jumping out the car.
Yes, it was unprovoked.
That's all I need to know.
No harm.
That was all I need to know. Now, at that point, unprovoked, again, once they get out the car, you're not saying anything to them, correct?
I'm backing up. Who is this, Rob? Who is these crackheads? Because they looking like crackheads.
Okay, did you
That's
call?
what I'm asking them. Who are these crackheads?
Also,
They acting like fiends. That's what I'm saying. I'm telling you what I was saying because they approaching me aggressive.
Okay, so at this point.
And I'm backing up.
Hold on. They get out the car, you haven't provoked them, correct?
No.
Okay, now, once they get out the car, is that when you call them crackheads?
Who are they who is this, Rob? They saying, who is this? I'm saying, who is this? They looking drunk. They looking high. I'm telling you, they were on my head instantly. They wanted to fight.
All right.
The girls wanted to fight.
Okay.
No matter how you sitting here, they wanted to fight.
Okay, and so at that point, you saying that mace was sprayed at you?
She sprayed the mace. She was on this side. She sprayed the mace, and I took off running. Her girl got the bat. Robert put his arm up. I took off running.
So at no point did the mace ever hit you?
Yes, it did. She sprayed my whole side as I'm taking off running.
Oh, so
she just did not mace me in my eye. She sprayed my whole side as I'm taking off running.
Okay,
she did.
You were hit by the side of the face with mace?
Whoopee, my whole side as I'm running.
In the face as well?
My side, up under all this.
Okay.
From the down. She did not mace me in my eye. She attempted to mace, and the mace got on me as I'm taking off running.
The record should reflect that when she says all of this, she's raising her hand from the bottom of her chin, all down, her hand is running down the side of her left side of her body.
So it got on your skin?
Yeah.
The mace did?
The mace.
Okay.
As I'm running.
I'm sorry. May I request that Mr. Quinn please keep your notes?
My mask is on, and I'm happy that you got your mask and you're behind plastic, but my mask is on and I'm conducting, and I would appreciate you allowing me to conduct my cross-examination.
Oh, I think her concern was that it's dipping under your nose.
I've been keeping my mask adjusted, and this is the second time that she has addressed this issue, because the last other times, of course, she did the same thing.
Oh, I didn't.
And no, it was on another case.
Oh.
And so I have maintained my mask because I know that's a concern of her. It has not been below my nose.
And the policy of the court, Judge, we're supposed to be covered.
And I am covered.
Okay.
I am covered. Thank you.
All right, let's move on.
Okay.
It is a policy of the court, Madam Court Reporter, it is correctly stated that. I think she's just concerned that everybody's
And as well, now I have been covered, and I don't think it's appropriate for her to interrupt my cross, but that's.
I was addressing the judge.
Okay.
Thank you, let's proceed.
Now, so it did get on your skin. Did you at any point, did you indicate that Mr. Ambrose also assaulted you?
Mm-hmm.
He assaulted you?
Yes, yes.
Did he assault you prior to this
No, it
interaction?
was after. The girls was gone after.
Okay. And so then you've just been maced. So then the two, Whoopi and the other girl, they get in two separate cars, is that correct?
Yes.
You've already left.
What do you mean, I already left?
You said you went by a fence.
No.
You didn't go
I
by
didn't
gate?
leave. I
No,
still was,
you moved from where you were at.
I'm coming back upwards.
You're coming back towards them.
Yes, they chased me this way.
And so you're coming back towards them?
Now I'm coming, ain't nowhere else to run. I don't have no choice but to come back this way.
Okay, but I'm saying you're coming back towards
I'm
Miss
coming back
Johnson.
towards Cadillac. Ain't nowhere else to run.
I'm asking you, are you coming back towards Miss Johnson and the other lady?
I'm coming back towards everybody that way. Everybody. Ain't nowhere else to run.
But they did not chase you.
They chased me that way.
Okay, and then they got in their cars.
I don't know when they got in their cars, because by the time I'm coming back this way, she was in her car, and thank God it was a tree for me to climb in, because the girl was trying to run me over. As I'm coming back this way, I ran back that way too far. Wasn't nowhere, I couldn't go nowhere.
Now, was that the exit?
It was not an exit, I couldn't go any further.
No, was that
It was trees, I don't know what it is, it was trees, it was a lot, it was something, it's on the side of Cadillac, it's a video.
But what I'm saying is, you took a video, or you saying it's a video at the?
All that stuff is recorded.
At the Operation Get Down?
All that stuff it's on the side of Cadillac.
Okay.
That lot on the side of Cadillac, all I could do was run back. Once I ran back so far, I had to come back up.
Okay. I got you. And so, but once they passed you, you said they almost hit you, correct?
What do you mean once they passed?
Once they passed you, their vehicle.
She never passed me. She was coming for me.
Oh, so the car, you were already up in the tree by then?
No, I wasn't. I climbed in a tree when she was coming for me with her car.
Okay. And at that point, you climbed in the tree. Did the car exit at that point?
She went on about her business because she would have hit the tree. She was already in the tree.
So
it was a tree. I was able to climb in.
So there was an exit there for the car to leave?
No, it was not.
So
Exit for. So if her car coming this way and she trying to hit me in the tree, that means she got to be over a curve in the field.
Okay.
She then proceeded to go that way when she couldn't hit me no more. The other car went that way. They both went towards Harper's way.
Okay. And then after that, you didn't get hit by the car. You're saying.
Because I was in a tree.
Right, I got you.
If I wouldn't have ran in that tree, she'd have hit me.
That you got Mr. Ambrose then assault you, correct?
Later on.
Okay.
I thought they were gone.
At any point, did you seek medical attention for the mace or the assault by Mr. Ambrose?
No, I did not seek medical attention for the mace.
Or the assault by Mr. Ambrose?
What's the medical attention? Cold water?
No, I'm saying, I don't know. I'm just asking you.
Yeah, I'm seeking attention for the assault from Mr. Ambrose. I do. I see therapy. I see all that.
No, I'm saying, did you?
I did.
No, I'm saying, did you go to the hospital?
I did. I went to seek medical treatment, therapy, everything for the assault from Mr. Ambrose.
You went to the hospital?
Everything, and I'm currently in therapy.
No, not therapy. I'm saying medical.
Medical and currently in therapy.
Okay, did you, let me ask you this then.
No, I know,
I
I'm
got
sorry, I'm asking Mr. Quinn.
Currently
I
in
want to
therapy.
keep, hold on.
Well, I just want to know.
Hold on. I want to confine this examination for Miss Whoopi Johnson to Miss Whoopi Johnson and any actions she may or may not have taken.
Understood.
Thank you.
After you were maced by Ms. Johnson as well as almost hit by the car, did you seek medical attention based on those?
Seek medical attention.
Based on what day did you go?
But I don't have the exact date. mistake that I went.
Did you provide,
Made medical attention, physically, mentally, everything.
did you provide the prosecution with your medical reports?
Prosecutor never asked if I wanted medical.
I would just say for the record, if I could get those medical reports, Judge, I never got them. And just for the record, also, if there's a video, if I could get a copy of the video that she just mentioned, Judge.
I don't know that Mr. Bloomers has a copy, but certainly if there is a green light video that may or may not exist, if you could check on that, Mr. Bloomers.
Absolutely, no, Judge.
Thank you.
I have no further questions, Judge.
Any redirect?
No redirect.
Thank you. Ms. McFauley. Any further witnesses for the prosecution?
No further witness, Your Honor.
Mr. Defense?
No witness.
Is there a motion?
The people move to find over on all charges and reserve argument.
Mr. Quinn?
I would say it's a question of fact.
I would agree. There is a question of fact that does exist on the record here. Ms. McFauley has testified rather succinctly and identified the defendant as an individual that not only maced her, but attempted to run her over with a motor vehicle that she would not have successfully been able to avoid had she not been able to climb a tree. With that being the case, I am satisfied that the prosecution has met their burden here to establish by a probable cause standard crimes were committed, City of Detroit, County of Wayne, and that you probably committed those crimes. As such, you are going to be bound over as it relates to count 3, assault with a dangerous weapon, felonious assault, that being the motor vehicle. Count 4, assault with a dangerous weapon, felonious assault, that being the mace. So again, counts 3 and 4 as listed on the complaint are going to be bound over to the circuit court for further proceedings with an arraignment on information date of August 3rd at 9 a.m. Anything further?
Nothing from the people, Your Honor.
Nothing from the bench, Judge.
Please make sure, Ms. Johnson, that you maintain the no contact provision that surely must be in place. That is really important. Yes, no contact, not directly or indirectly. No form of social media outreach, no texting, chatting, or even having anyone else act on your behalf to contact the complaining witness. It's real important because if it's violated, the consequence is that your bond could be revoked. So it's very serious, okay?
Yes, ma'am.
If you have questions about your bond, please make sure you speak to Mr. Quinn and he will explain it to you in further detail. Again, the arraignment on information date is going to be August 3rd at 9 a.m.
Thank you.
Thank you.
Thank you.
Anybody else in the hallway?
We have, Holyfield.
And is it proceeding?
Madam Clerk?
Hold on one moment, please. Thank you.
Thank you.
Hold on one second, we're gonna get to you. Hold on one second.
She turned his off.
Oh, okay.
Judge, I don't know. She's in there for me.
Oh, okay.
I was checking in for Durain. Yep.
He's here.
Beautiful.
Two.
So for
Calling parties on Gates. Case number 2060297, the people of the state of Michigan versus Brian Levert Gates. The defendant is charged with count 1, home invasion, first degree. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Remax with VP 82800 on behalf of the people.
Good morning, I'm Ray Elder, and for the case, my opinion was 57728.
Thank you. And your client?
John, I believe my client may have zoomed in. If he hasn't, Judge, I'm asking the court to,
Hold on, I think I'm bringing him in right now. We're gonna need a moment to connect to, audio.
If not by then we will just call it.
Mr. Gates, let us know when you're connected to, audio. This is odd, Tammy, I see.
Yeah, I'm trying to see what's going on.
Thompson is on top of this case and it shouldn't be.
Well, there's
Oh, there's
co-defendants.
co-defendants, okay.
Co-defendants.
All right.
I was trying to see if we could just adjourn this to the co-defendant stage.
Okay, Mr. Gates, are you connected to audio now? I think he's still trying to connect, Mr. Elder. It's still, it's showing on my end that he's still trying to connect. Can you hear us, Mr. Gates? No.
Hello?
I need Mr. Gates.
This is Mr. Gates.
Oh, okay, you got two devices. Could you log off on your second device, please?
Okay.
Thank you.
Is it done?
No, but I'll remove you. Can you state your name, sir?
Brian Levert Gates.
Thank you. Okay, so we're here today for an examination. It's supposed to be an in-person examination, so I'm not certain what you're doing in Zoom gallery.
Me and the lawyer got it confused. I thought he said come. I thought he said Zoom. I just got off the phone with him.
We need a new date, Madam Clerk.
Huh?
We're setting a new date because this is an in-person examination.
Okay.
Okay, hold on.
October 8th at 11 a.m.
October the 8th at 11.
Is that okay, Mr. Elder?
It is, Judge.
October 8th at 11. That's going to be in the courthouse, sir.
I hear you.
Okay, we'll see you then. Oh, make sure
Okay.
you comply with the bond conditions, and also make sure you arrive early on the date of your exam date, just in case you need time to pass through screening.
Okay.
All right, thank you.
All right.
Take care. You can log off.
You want me to call
All
Shepherd?
right.
Please.
Calling parties on Shepherd, case number 2058625, the people of the state of Michigan versus Victor Leroy Shepherd. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Mr. Ray Elder, Mr. Schufer, Your Honor, which I believe is going to be Zoom as well.
He actually is not. That was just Mr. Gates. Mr. Gates had two devices.
Okay.
I thought one belonged to each of your clients, but he is not present.
Judge, I just got off the phone with him, and that he thought it was going to be via Zoom as well. Yeah, and I can tell you this, that I heard what the court heard the last time we set these for examination, so I'm just as surprised when my clients told me they thought it was via Zoom.
Let me ask, are there any concerns regarding bond?
None from the people. I wasn't sure if we wanted to wait till 11:30 to see if I even have a
I
witness.
can't, do you have, no one's checked in yet?
Not to my knowledge.
Okay, what I'd like for you to do then, Mr. Elder, is zoom back in at 1:30 if you wouldn't mind, with your client.
I sure will.
And in the event that Mr. Bloomers did not have a witness that showed up, then I will allow you to make a motion even over Zoom.
Got it, thanks, Judge.
Okay, otherwise,
Otherwise, though, if he's just a no-show all day,
No, don't be.
then we may have to take another route. Mr. Bloomers, will you be available to join us via Zoom at 1:30?
Yes, Judge.
Thank you so much.
Thank you.
I'm gonna just hold on to this.
1:30 or 12:30, Judge? Okay.
Yeah.
That's fine. And then,
'Cause
I got you. Public Works attorney, they Calling parties on Holyfield, case number 2157112. The people of the state of Michigan versus Cameron Holyfield. The defendant is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3 and 4, weapons, felony, firearm. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Laura Morales Smith, PA 3353 for the people, Your Honor.
Calling parties on Holyfield, case 2157112.
Okay, and good afternoon, Your Honor. Good afternoon to your staff. May it please the most honorable court, Mohammed Nasser, E74485, appearing on behalf of Mr. Cameron Holyfield, who also appears standing behind me to the right. Mr. Holyfield, please identify yourself to this court.
Hi, I'm Cameron Holyfield.
Thank you. Madam Prosecutor, are we proceeding to an examination today?
Your Honor, I was at the court earlier at our time for an examination. The complaining witness is not there at that location at that time, and the people cannot proceed without our complaining witness.
Is there a motion?
Your Honor, defense would move to dismiss this case, please.
It is currently, I don't have my watch. Currently 1:16 by the court's clock, and this matter was set for, I believe it was 11 a.m.
Yes,
And the defendant.
Yes, Your Honor.
The defendant is present, however, the prosecution is unable to proceed. With that being said, I'm going to grant that motion to dismiss. The matter is hereby dismissed without prejudice, which means, Mr. Holyfield, that it is possible that the prosecution can reissue on this case. If you have further questions regarding the parameters of that, please make sure you speak to your attorney and he will explain it to you in greater detail. Do you have on a GPS tether that needs to be removed?
Yes, he does, Judge.
Okay, I'm going to add that language to the order. We will also notify the tether unit from our angle here. But it's always a good idea to have your own copy of this order, so there's no confusion when you go to the tether unit. Is there anything further from either the prosecution or defense?
Not from the people, Your Honor.
Nothing from defense, Judge. We thank this honorable court.
Okay, we're all set. Then I just need your signature on this document as the moving party on the order of dismissal.
Yes, Judge.
Thank you.
I'm sorry, Madam Clerk?
Yes, ma'am. May I please have the P number for the prosecutor again, please?
Ms. Morales Smith, your P number?
Yes, Your Honor. It's P83353.
Thank you.
And can Madam Clerk please email me the copy of dismissal?
I will.
Thank you so much. Have a good day.
You too. Thanks for zooming in.
Thank you.
It's calling parties on Wicker. Case number 2157505, the people of the state of Michigan versus Isaiah Wicker. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle, habitual offender, third offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good afternoon, Your Honor. Jacob Slusky on behalf of the people, P83677.
Good afternoon, Your Honor. J. Grant Miller, T58658, on behalf of Mr. Wicker, who is not present.
Okay, and Mr. Wicker should be present. Is there something going on with him that we should know about?
Your Honor, and I've explained this to Brother Counsel, Mr. Wicker, since I was appointed on this case, has become homeless. He has changed several shelter locations just because of spacing. He's had several phone numbers throughout my representation. I've been sending texts, they haven't been bounced back. But when I try and call now, the phone has been deactivated, so I don't know if he will reach out to me in the future. I'll have him turn himself into the court. I do know he's suffering some hardships at this time. If the court could note the file that if he is brought in, that it could be taken into consideration his substantial hardships.
Certainly, the court is sympathetic to that. However,
he was ordered to be here. Is this the case where there were certain things said on the record which caused us to go back on the record and not the next day?
No, Your Honor, this is a motor
And you were
vehicle he
thinking
kept
about
beyond
a
rental.
referral? And you were thinking about a referral?
Not my recollection, Your Honor.
A
We did at
competency
some
referral?
point, we did at some point, he came on.
I have
and
those in my notes,
Somebody
so.
might have been covering for you that day. He did make some comments about he was
Oh, that's what I'm talking
semi-suicidal.
about.
And he did actually get mental health. So I don't know if he's in treatment, nobody's contacted.
What did you think I was asking when I said that?
It took me a moment.
Oh,
Your Honor.
yeah.
This is my 14th matter today.
Oh,
And you're
okay.
about to hear my third Mr.
Listen,
Davis, my second Mr. John Davis. So
Listen,
it's a little
I'm
confusing.
impressed with your ability to multitask in this pandemic and technological age. I just had it in my notes and I'm thinking, I'm pretty sure this was that case where he made some statements after we closed the record. And then we brought everyone back, I think, the next day.
Yes.
I think you asked to come back.
Yes.
Because
And
you wanted to address it, and then you decided to not make a referral for competency, and we said it immediately, this is pretty immediately for a
Yes.
non-custodial matter.
Mr. Wicker did indicate after that hearing to me, he had sought mental help. He was seeing professionals about some of his concerns. I did not think to check any of the hospitals or the other programs to see if maybe he's inpatient somewhere,
Okay,
as there's a high probability that could be the case.
okay, well, since we do not know, that leaves us with limited options here. This was the date that was set, and Mr. Wicker was present. Now that my recollection is jogged here, he was present on June 22nd. And also present on June 24th, wherein that exam date was set. The exam date was actually set on June 22nd, and it was cemented and confirmed on June 24th. So he certainly knew about the date, and there could be a plausible explanation for his failure to appear here, but being as though we do not know, is there a motion?
There is, Your Honor. First, I just want to say, I believe I previously said I didn't recall that circumstance you laid out. I have enough notes in this case. I had to scroll down a little bit and I see what you're talking about, that is correct representation, that considered competency evaluation. The people who have a motion to issue a capias the people move the court to issue a capias. In the event that there is some legitimate explanation, like some kind of inpatient treatment, the people certainly wouldn't object to setting aside the capias, but at this time, we have to request that capias because Mr. Wicker is not present.
That motion is going to be granted. The capias will issue. Previous bond is revoked. I'm going to set new bond at $5,000 cash or surety. Certainly, if you are able to establish contact with Mr. Wicker sometime today, we should be on the record for quite a bit. We've got a double bagger that we're getting ready to start. So you certainly can Zoom in with him later today, if you're able to. If not, please alert the court if there's something that you find out after the fact, after today, because it will be entered today is really what I'm trying to relay. Probably after 3 p.m., the capias will enter. So if it's sometime after that, typically the normal course in which one would respond to an open warrant is the course that should be taken. Unless, however, you have some special circumstance to present to the court that might explain why he was not present, and we can address it on Zoom that way.
Yes, Your Honor, the only request on behalf of defense is that some notation be made on the capias. I don't think picking Mr. Wicker up and putting him into general population at the DDC is a great idea. If somehow it can be marked medical, that he be put into an observation unit if he is arrested. Because of his previous ideations he made, whether on the record or off the record, I don't want him not being observed if he's picked up. I don't want him to harm himself potentially. I know how that works with the county. I'm not sure how that works with
Yeah,
the Detroit
I don't
Detention
know
Center.
if I could make a notation here on the bottom of this form. I guess I could just make a little addendum to the form.
That makes sense to the people.
Matter of fact, I'm going to hand it to you. And you can make it in a little, put an asterisk and put a and some added remarks, so long as Mr. Slusky is in agreement with what those remarks might say, in the event that
Actually,
he's
after I
picked
can
up.
read it, after you, oh, sorry for my.
In the event that he's picked up.
Your Honor, and my special request is, my printing is akin to a retarded chimpanzee, so if I
okay.
can work with Mr. Slusky, if he can print better than I can, to put that language on the bottom.
I'll do my best.
Mine is.
I will just say though, as the person who's gonna make the entry, I don't know if in lien, that will take that. I can put it on that form and I'll make an entry in JIS. I'll try to put it in lien, but I'm not sure if it will accept it.
Okay, and I know it works with Wayne County
Okay.
Sheriff, because I've had other clients that needed observation when picked up.
Okay, I'll try it then.
I'm just not sure the mechanics of the DDC.
Yeah.
Okay, so you want to say, please place.
Okay, if you could just, we're gonna call another matter, you can slide that to us when you're
Oh,
ready.
of course, that makes sense.
Actually, we need Mr. Miller for this next case too.
Oh.
So
And the next one,
let's call
too.
this and then y'all can go back to that.
Okay.
Calling parties on Davis, case number 2155518. The people of the state of Michigan versus John Davis. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Good afternoon, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good afternoon, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Davis, who sits in the hallway. I don't know if he's walking in now. He was here at 11:30 and he was checked back in at 12:30. He's out in the hallway.
Did the officer go get him? Do we have a third officer? John Davis. We need John Davis.
Make sure we take this
Did he
out.
do? Oh, he have that on?
Yeah, he's got a ball cap on. Bright colorful.
Good afternoon. Please state your name.
State your name.
No, John Davis.
Thank you. All right, today is the date and time set for a preliminary examination in this matter. It was set for, I believe, 11 o'clock. It's currently 1:26. Were there any witnesses that appeared in this matter?
Yes, Your Honor. The complaining witness, Florence Wilson, did appear at the courthouse on time for the 11:30 exam. And I did have a chance to speak with her and explain that there was an adjournment because there had been an emergency. But she was present on time this morning.
Okay, the record should also reflect that Mr. Davis is not in custody. While he is present, he is not in custody, and the court did have to break the record at 11, I believe it was 11:20 or 11:30, and with the idea that we would pick back up on Zoom to address an adjournment if there were witnesses, because we do have an afternoon docket that is going to start at 1:30. So, given that this is a non-custodial matter, we cannot turn this around next week or the week after that. But I'm hoping that we can find a date in either late August or early September.
We can do August 16th at 9:30.
That was August 1/6.
Yes.
Your Honor, I can tell you that 9:30, I have 5 other courtrooms.
Yeah, no, and I
All right.
understand. Let's go for September.
All right. That's changed too, but. September 10th at 9:30?
September 10th, I have 4 matters in the morning. If we could do it at 11:30, I can do it. It's, most of my Zooms, I'm generally done by 11.
Okay. So we can do 11:30, September 10th at 11:30.
Okay, September 10th at 11:30 in the morning will be the new in-person examination date. So please report to the court on that date, sir, as you did today.
And I apologize, Your Honor. This is Mr. John Davis, correct?
Yes.
Yes, okay. Again, I apologize.
Yes.
Too many Davises.
Yes, yes. All right, September 10th at 11:30. Are there any concerns that you had with bond, Mr. Bloomers or Mr. Miller?
No concerns at this time, Judge.
None that defense has been made aware of at this time, Your Honor.
Okay. We are all set. The bond will continue.
Thank you, Your Honor.
Thank you, Judge.
Thank you. What happened with Shepherd?
That, we did that.
We already handled that?
We already did that.
Oh, I thought so, because the elder was here.
Yeah, we already did that.
All right, so that leaves.
Just have the
Johnson and
afternoon.
Matthews.
Yeah, we just have the afternoon.
Why do I feel like we started this one? Blake and Clemens, I feel like we heard them on the record, but it doesn't look like the held apart.
Yeah, or it could have just been injured wrong.
Maybe they.
Maybe adjourned or something. Judge, two things real quick before they come in.
Mr. Elder.
He's on Shepherd. Yeah. Mr. Elder?
I'm here.
Hi, so, Mr. Shepherd, was he going to zoom in?
Yes, Judge, I just got the phone with him. He just didn't have the number. I gave him the number. He's just zooming in a minute.
Who's the prosecutor on this afternoon?
Carter. He's already checked in.
Oh, can you let Carter know he can come?
Everybody can come in. We're ready. All the
I never
parties.
understand why the attorneys stay in the hallway.
I think. I can't remember.
They want us to walk them in.
I guess. Because sometimes they tell me they must let them come in. They must turn the air off.
Now, that's interesting.
I saw Jacob.
There he is.
I saw him though.
Yeah.
And then I had to let him in. But he was
That's
here.
when he was there.
But he
That's
wasn't
weird.
here. So that poses a very interesting.
That's weird.
Can people appear in that gallery? Even when I think I'm creating a waiting room? I don't know.
Good afternoon. ma'am.
Mr. Elder, as soon as you see your client, let us know and we'll break in the middle of this. We're getting ready to start an exam.
Thanks, Judge. Do you have a waiting room or not?
I'm sorry?
I won't be able to see in the waiting room though, Judge. That's the only issue.
Well, oh yeah, I will let you know because it will chime for me.
That's not even arrested on his way.
Mr. Bloomer, Mr. Elder was asking if you had witnesses.
I do.
You do?
No, I do not. I had an advocate who was there until the lunch hour and to confirm that they did not show up.
Okay, so Mr. Elder, what I was saying is that when someone tries to get into the waiting room, it chimes, it beeps. So I will know and I will let you know, we'll break in, but we're getting ready to start an exam. So I didn't want you to think I'd forgotten. But if your client could hurry and get here, we can get you in and out.
Judge, would it be easier if he calls in or?
I don't know, does he have technological issues?
He's actually calling on the line right now.
I don't know, like, you tell me what's easiest.
Let me ask the judge.
Mr. Elder looks like the background could be like Miami or something. Where'd he go? He just left us a few seconds ago. Where's your office located, Mr. Elder? Oh, okay.
33 and all this 40. I called it, but it ain't picking up.
Hi, Mr. Blake.
Oh, hi, Judge.
We're getting ready to call. Is Mr. Clemens here?
Judge.
No, I can't. There's lots of objects between me and.
Good afternoon, Judge. First, I'll say that, but yeah, I haven't seen Mr. Clemens here yet, and I don't think the defendants are here either.
Judge.
Okay. What do you want us to do, Mr. Elder? We'll do whatever you want us to do.
Can I have a phone number to have my client call, Judge?
Sure. 965-2282.
Okay, please, you can call right now. Thank you.
Sammy, do we have a phone number? Maybe Mr. Clements had it mixed, the timing mixed up. I would hate for us to be sitting here
And I'll send him a text too, Judge.
Thank you.
In attorney time, he's only 5 minutes late.
What about me?
He's actually on time.
He usually beats me.
He does. That is kind of worrisome.
That's what COVID does. Change everything.
Judge, my
No.
client's
I think that's maybe Judge Archer's courtroom, Tammy. Okay, just a moment, sir. I'm gonna put you on speakerphone, okay? Okay, sir.
Yes, this is Victor Schubert.
Okay, this is People versus Victor Shuford, 200-58625. This case was already formally called. Today is the date and time set for a preliminary examination. Well, actually, it was set for an examination to begin at 11 a.m. and it's currently 1:37. Appearances, please.
Jacob Bloomers on behalf of the people.
Good afternoon, Dorade Elder. On behalf of Mr. Shuford, my P number is 57728.
Thank you. And Mr. Shuford, could you state your name once again, sir?
My name is Victor Schubert.
Thank you. All right, with today being the date and time set for an exam, was the prosecution ready to proceed with witnesses?
Your Honor, at the set time for this exam, which was 11:30 this morning, the complaining witness, Ben Shao Hall, was not present in the courthouse. I was present, as well as a victim advocate who was there until a little after 12. They did not present themselves. Without their presence and participation, the people would not have been able to go forward with their exam.
Is there a motion?
Yes, Judge. With that being said, I'm asking the court for a dismissal without prejudice.
Thank you. So I am going to grant that motion. The matter will be dismissed without prejudice, given the representations that have been made. Mr. Elder, do I have permission to sign your name to the order of dismissal as the moving party?
Yes, Judge.
All right, we're going to forward a copy of this dismissal to both the prosecution and to the defense. Mr. Shuford, do you have on a GPS tether that needs to be removed?
Yes, ma'am.
Okay, I'm going to include the language on the order that the GPS tether shall be removed forthwith. And we're also going to notify the tether unit from our angle here. It's a good idea. I don't know. It's not completely necessary because we will be notifying them. But Mr. Elder, I always do suggest that any individual who's getting their tether removed have a copy of this in their hand, the order I'm preparing, so there's no confusion. I don't know if you can get that to him today, because I'm sure he wants to get the tether off today. So he's certainly free to go. As I indicated, in a few moments, we will be notifying by email the tether unit. So it should be fine for him to go proceed to the tether unit to get it off without this order, but if you could get it to him, that would be even better.
That'd be great, Judge. I definitely will.
Is there anything further?
No, Your Honor.
Nothing from the defense, Judge. Thank you for your patience.
We are all set. Thank you so much. Have a great afternoon.
Thank you, Judge.
Any response from Mr. Clements?
He's on his way, Judge.
Is your client here?
He's on his way, Judge.
Oh, boy.
And the other defendant, he's on his way.
Oh, boy.
Everyone's on their way.
Yes. They'll, or like Kevin would say, they'll be here shortly.
Shortly, right. Shortly could be interpreted in so many different ways.
I'm free up until 4, Judge. I have a Secretary of State.
You said up until what time?
4 o'clock.
All right, well, that gives us a little bit of room. How many proposed witnesses do you have?
Hopefully 3, but depending on how the testimony goes.
Yeah, and there's 2 cross-examinations. What did you say you have at 4?
Secretary of State.
What's that? I mean, what do you mean?
Secretary of State. I gotta go and get.
Oh, you have an appointment.
Yeah, I gotta do a few things, it takes a while.
Yeah, it's nice that we can make those appointments.
Yeah.
I haven't, post-pandemic, I wonder if it's a swift, smooth process, I don't know.
I'll let you know.
I think the hardest part is actually getting that appointment.
That's true.
Yeah.
That's the hardest part.
Yeah.
Unless you pay somebody $20 who works there.
Right.
He don't want to tell you that.
But who would do that? That would be.
I don't know, not me, Judge. Okay.
Oh, sorry, yeah. We are always recording though. And the court, unlike before, we have a court reporter here who's taking it. It used to be if that mute was not recording here or not unmuted, we would have nothing because the court reporter usually was always on Zoom.
Gotcha.
Now, fortunately, we have a court reporter here. Thank you so much for being with us here in the courtroom here today. I know it's new that the court reporters are back in the courtrooms and we are recording on these devices that are illuminated, but thank you for pointing that out.
No problem.
We do not need to repeat anything. As I've indicated, everything has been transcribed. Not transcribed, but will probably be transcribed at some later point. Did we figure that situation out?
His wheelchair is a smaller one.
Oh,
I can't
okay.
guarantee that it'll fit through there, but we might do it.
Okay, all right, well, all we can do is try.
And Your Honor, if I may, a third preliminary matter, Your Honor. At some point in time, it's the people's belief that certain witnesses will be attempting to make a in-court identification.
Okay.
As we were in the middle of a pandemic, you know that everyone in this courtroom has masks on. I may ask the court to order everyone for a very brief moment to remove their mask for approximately 5 seconds for a proper in-court identification, Your Honor.
And I have no problem with that. I have done that upon request in other cases. I don't know if the defense has an objection they would like to put on the record, but I certainly am going to allow that in the event that prosecutor asks.
There's the only objection that I would put on the record, I'm sure Mr. Carter is aware of this already, as it relates to Mr. Matthews, that the complaining witness was showed a photo where that included Mr. Matthews and he didn't identify him. So I think for him to be sitting here now in the courtroom would suggest to him that he should have identified him before. So
Objection noted.
that would be my objection.
Objection noted, but if Mr. I don't know that he will, but if he asks, I am going to allow it, and you certainly can. That can still be fertile ground for you to argue at a later time if necessary.
But that's why I was putting it on the record now, so we'll have to deal with it.
Yes, the objection is noted, but again, if the question comes up, I don't want this to turn into a hearing on that. I am going to allow the request to be made, and I am going to ask everyone to lower their masks if it's asked. He's indicated it seems like an if then, but if he does ask at that particular juncture, I am going to allow it. If you want to pause and if we want to have a mini hearing on that issue now would be the appropriate time and not at the time.
No.
Okay.
I think the law allows for him to still be asked just because he did give an identification before. But no, that would be the only proofs I'll place on the record.
Okay, and your objection is noted. Anything further?
No, Your Honor. At this time, the people call Levert's neighbors to the stand, Your Honor.
Thank you. Did you need the share screen? Because I did enable it.
Thank you, Judge. That was the last thing that I meant to note and overlook out. Yes, there will be, the people intend to propose 2 electronic exhibits, Your Honor. Okay. And the people will be asking for this court to allow the people to use the share screen function.
I have already enabled it in anticipation of that when I saw you zoom in.
Thank you, Judge. And if I can also note, sorry, Judge, I should have brought this up before. For that proposed exhibit, it's just a video. No audio is associated with it, so we shouldn't have any.
That makes it much easier from a technological perspective.
Indeed.
How long is the video?
Your Honor, for the first proposed exhibit is 4 minutes, and the second proposed exhibit 3 minutes, and Your Honor, there may be a third as well, that will be 3 or 4 minutes as well.
All right, just making sure it wasn't 2 hours.
No.
Can you please direct her as to where she?
Sorry.
Yeah. Or actually, if you could just pause right there just for one moment. Can you please state your name and then also spell your first and last name, sir?
Luvert Neighbors, LUVERTNADORS.
Thank you, and good afternoon. I was remiss in not saying that when I first saw you come into the courtroom. Could you please raise your right hand, sir? Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Oh, I'm sorry.
I need him to repeat his name again. I didn't do that.
Could you repeat and spell your name again, sir?
Luvert Neighbors, LUVERTNADORS.
E-R-T.
V as in Victor.
Yes.
Okay.
N-A-V-O-R-S.
Thank you. Thanks, sir.
And Mr. Carter, if you could please direct as to where you want him situated.
Advocate, if you can place Mr. Neighbors here facing, I will,
Face the other.
yes.
And when you are ready, Mr. Prosecutor, you may proceed.
Judge, the Madam Court reporter asks that the microphone move. I don't want to touch anything here.
Oh, now we used to have a table and we would have this microphone situated. Can we do that again? So that his voice is magnified. Do we have a table that we can?
I got a chair right here though.
Oh, a chair will work, I suppose. Right?
Yes, ma'am, I got it.
The chair's actually, the table's right there.
Can you hold it? Huh? Well, let's see if we can.
We don't have a little table.
Well, it's just right there. It can be slid over.
You want to see if you can hear him first?
Can you just
Can you
slide
say
that
something?
little table there?
State your first
Right
name.
there?
Just so she can, we can do a test, run. Say your first and last.
She wants
Oh,
some
she's
stuff.
got.
to
Oh,
show.
oh, okay.
You want to hold it? Are you able to hold it? Okay.
Okay, that'll work. Thank you, Madam Officer.
You're quite welcome.
Okay, Mr. Prosecutor.
Thank you, Your Honor. Good afternoon, sir. Please state your first and last name for the record.
Levert Neighbors,
And spell your first name.
L-U-V-E-R-T,
Spell your last name.
N-A-V-O-R-S.
All right, now, Your Honor, I asked this court to inquire with Madam Clerk, Madam Court Reporter. Judge, I can hear my complaining witness, but I'm inquiring with the court, if the court can hear clearly.
I can, and I would also just though request, sir, that you try and keep your voice up as nice and loud as you can. So not only I can hear you back here, but everyone, including the court reporter, because her job is to take down every single word that is said here. And it's really important that we get it right, okay?
Okay.
Thank you so much.
If I may, Your Honor?
Yes, please.
All right, so, sir, I'd like to turn your attention to November 11th, 2020, at approximately 7:05 PM. Do you recall that date and approximate time?
Yes.
Okay. Now, did something ultimately happen to you on that date and approximate time?
Yes.
What ultimately happened to you?
I was robbed and shot.
Okay, all right. So let's go ahead and take it back a bit. At what location were you when you indicated you were robbed and shot?
At a gas station.
Okay, and do you recall which street that gas station is on? Or was on? If you know, if you remember.
Southfield and 8 Mile.
Okay, is that in the city of Detroit, County of Wayne?
Yes.
Okay. Now, how did you get to the gas station?
I drove my vehicle,
Okay, what type of vehicle did you drive?
red Impala with a black bumper.
Okay, a red Impala?
Yes.
Okay. How many doors?
4.
4 door? Okay. All right. When you went to the gas station, were you alone or with others?
I was alone.
Okay. Now, sir, what brought you to that gas station?
Getting gas.
Okay, all right.
Okay, any other reasons?
To meet up with a customer.
Okay. Now, you said to meet up with a customer. Do you know who that customer was?
Yes.
Okay. And at the moment, well, strike that. How did you communicate, if at all, with this customer to go to this particular gas station?
My phone.
Okay. And did you know the customer's name at that moment?
No.
Okay. Now, and just to be clear, you said a customer. Were you selling anything?
Yes.
What were you attempting to sell?
THC edibles.
Okay. Now, you go to this gas station. You say to meet a customer, correct?
Yes.
All right. And you did you stop the car or park the car anywhere?
At the gas pump.
Okay. When you pull up at the gas station, what happens next?
I waited a while.
All right, now I'm stopping here. You say you waited a while. Approximately how long, if you remember? A minute or two. Okay, and then after that minute or two, did anything else happen?
Yes.
What happened?
A guy jumped in my vehicle on the passenger side.
Okay, now you said the passenger side. We're talking about the rear or the front?
The front.
All right. Were you expecting for someone to enter your vehicle?
No.
Did you give anyone permission to enter your vehicle?
No.
All right. What happened next?
When he entered the vehicle, he made a statement. The statement was run your shit or run that shit.
Okay. And what did this person look like? Is it, you said he, is it a male or a female?
Yes, he.
Male?
Male.
Okay. Ethnicity? What color was the person?
Black.
Okay. And he said, run your.
Run that shit.
Okay. And what did that mean to you?
I was being robbed.
All right. And did you observe or notice anything about that individual?
He had a hoodie on and he had a gun in his pocket.
Okay. Now, you say he had a gun in his pocket. How were you able to make that determination that this person had a gun in his pocket? What did you?
He was pulling it out.
Okay. So, so he was pulling it out.
Yeah.
Did this person ever pull it out?
Yeah.
Okay. Did you have an opportunity to see this gun?
Yes.
All right. Do you know the difference between a long gun and a handgun?
Yes.
How would you describe this gun?
It was a handgun.
Okay. Now, when this person made that statement to you, what did you do, if anything?
I reached for my weapon.
And is there a reason that you reached for your weapon?
Because I was being robbed.
Okay, right, that's right. Right. Okay. Just give me the answer, okay? So, because the judge knows nothing about this case. So even if it seems obvious, I need you to go ahead and give me a full answer, okay? All right. Now, where was your gun prior to you retrieving it?
Under the seat.
Okay. All right. You retrieved your. Were you successfully able to retrieve your firearm?
Yeah.
All right. What happened?
Pardon, what was the answer?
Repeat your answer. Let me ask you the question again. Were you successfully able to retrieve your firearm?
Yes.
Okay. What happened next?
He struggled. I was trying to knock his gun away. He was trying to knock mine away.
Okay. What happened next? Did you hear anything? Did you hear the sound of anything?
Yeah, I heard a gunshot.
Okay, how many gunshots did you hear at that moment? Just at that moment, if you remember.
2 or 3.
Okay, now, did you feel the impact of gunfire? Did anything happen to you physically at that moment?
Yes.
Or what happened to you physically?
I noticed that my hand had a hole in it.
Okay, what hand is that?
My left hand.
Okay, where on your left hand?
Right under the ring finger.
Right on, is it on your ring finger?
Yes.
Okay. And what did you notice about your ring finger?
That I could look through.
Okay. Has you been shot in that finger?
Yes.
As a result of that, what did you do next?
I tried to get out the vehicle.
Right.
Throw down the door handle with my left hand.
Okay, you attempted to open your door with your left hand? Okay, as opposed to your right hand? Okay, and what happened next? You attempted to open up the door?
I still heard gunshots. And I was able to make it out the door.
And I'll stop you there. So you made it outside of the door of your vehicle, correct? And what door did you exit?
The driver door.
Okay, and when you made it outside of the door, what happened next?
I took a few steps and then fell to the ground.
Right, and during this period of time between taking a few steps and falling down, did you hear anything?
Yes.
What did you hear?
Gunfire.
All right. Now, do you know the difference between the sound of gunfire from one gun versus multiple guns?
No, not at this time.
Okay, no, that's fair. All right. So, while you were outside, while you were outside of your vehicle, you said you heard more gunfire, correct?
Yes.
Did you see anything with your eyes at that moment?
So there's another guy.
All right, I'm gonna stop here. Now, you said there was another guy, and this is a different guy than the person who got into your vehicle?
Yes.
All right, and where was that guy positioned, if you remember? General idea.
Like on like my back, left shoulder.
Okay, so is it fair to state that this person was behind you?
Yes.
Okay, and did you notice anything about this person? What was that person doing, if you know?
Looked like he was firing shots at me.
Okay, firing shots at you from what?
From firearm.
Okay. So as this second person is firing shots at you, what do you do?
I had fell to the ground because I ain't know at the time, but a bullet had hit my spine.
All right, I'm stopping you there. You got out of your vehicle. Were you attempting to go somewhere?
Yes.
Where were you attempting to go?
Inside the gas station where it's bulletproof.
Okay, and why were you trying to go inside the gas station?
For safety.
Okay, all right, that's fair. Now, you mentioned that you were unable to get into that gas station, correct? Right. And why were you unable to go into the gas station?
Because I got shot and fell to the ground.
Okay, and where were you shot?
In my back.
All right. Now, as you were, once you fell down, what happened next?
I was calling out for help and I was trying to get back up and couldn't.
Okay. Now, did the help arrive?
Eventually, yes.
Okay, in the form of EMTs or EMS?
Yes.
Okay. And were you transferred to a hospital?
Yes.
What hospital?
Sinai Grace.
Okay, and how long were you in Sinai Grace? If you remember.
Week and a half.
Okay, and do you know the extent of your injuries?
Yes.
What are the extent of your injuries?
I'm paralyzed from the waist down, and I'm missing a section of my finger on my left hand, and my right arm got nerve damage.
Do you know how many times you were shot in total?
No. You said 4 or 5.
Okay. All right, now, sir, let's talk about person one. I'm going to call this person one. You indicated that a person went into, got inside your vehicle, correct?
Yes.
All right. Now, I'm going to ask you, sir, in a moment, not at this particular time. I'm going to ask you to look around this courtroom, okay? We're only talking about person one right now, the person who got into your vehicle, okay? I'm going to ask you to look around this courtroom and see if you recognize the person who I depict as person one, who you depict as a person who got into your vehicle. And Your Honor, at this time, I'm going to ask this court to instruct every person in this courtroom to remove their mask for 5 seconds, not at this exact moment. And Mr. Neighbors, I'm not trying to be insensitive, but typically I would ask a witness to stand up. Obviously, because of your condition, you cannot do so. If you need to be positioned elsewhere in this courtroom to adequately look at everyone's face, please let me know, okay? All right, Your Honor, at this time, I'm going to ask everyone in this courtroom to remove their mask for 5 seconds. Okay, put a mask on. Okay. Sir, do you see that person who you indicated who got into your vehicle in this courtroom today?
Yes.
Where is that person seated? And please describe an article of clothing that person is wearing.
So where is he seated?
Yes, point. Okay, what is that person wearing?
Collared shirt with a black bow tie.
Right. Your Honor, let the record reflect the in-court identification of defendant number 2, Jalen Matthews.
The record will still reflect identification of Mr. Jalen Matthews.
Now, sir, you indicated that there was a second person who you said was firing shots at you, correct?
Yes.
Okay, I'm gonna call that person second person. In a moment, I'm gonna again ask everyone in this courtroom to remove their mask. I'm gonna ask you to look around this courtroom and see if you recognize that individual, okay? All right, Your Honor, at this time, I'm gonna ask this court again to request everyone in this courtroom to remove their mask for 5 seconds.
Okay, please do.
Okay? Sir, have you had an opportunity to look around this courtroom?
Yes.
Do you see the person who I identify as the second person, who you identify as the person behind you firing shots?
Yes.
Where is that person seated, and what is that person wearing?
Sitting over there with a black and white striped shirt.
Your Honor, let the record reflect the in-court identification of Mr. Ronald Johnson, I believe defendant number 1.
The record will reflect identification of the defendant, Ronald Johnson.
Now, sir, we've had an opportunity to speak prior to today, correct?
Yes.
All right, and did I show you a video?
Yes.
Or 2 videos, essentially?
Yes.
Okay, and generally speaking, what did that video depict? What did you see? Without great detail, what was it of? What did I show you?
What was happening outside of the vehicle?
Where?
And robbed and shot.
Okay, all right, and did those videos fairly and accurately depict what happened to you on the day in which you were shot?
Yes.
On November 11, 2020?
Yes.
Your Honor, I move for admission of People's Proposed Exhibits number 1, a video from camera 1, and People's Proposed Exhibit number 2, video from camera 12.
Is there any objection to the admission of People's Proposed 1 and 2? I'm assuming you've had an opportunity to review it.
No, there.
Any
No
objection?
objection. They have
Any-
attended one.
Any objection, Mr. Clements?
No, thank you.
Okay, will be admitted as People's Exhibits number 1 and 2 respectively.
Thank you. May I publish, Your Honor?
Yes.
Just for the record, video is, just maybe an hour long or so. I'm only going to,
That was not him.
What were you saying, Mr. Carter?
I'm not sure if it was my computer or not.
Mr. Clements just, I let him into the Zoom gallery and he just muted.
Sorry, Judge, thank you. I'm only going to be playing approximately 4 minutes of video from People's Exhibit number 1, which is camera 1. I will attempt to start the timestamp at 19:27:40 through 19:31:24.
Okay, is there any objection from the defense to the limited version of what is being shown?
No, on behalf of Mr. Johnson.
I concur, Judge. Thank you.
Thank you, Judge. And Judge, I'm actually just gonna start from 1927-28. That is the timestamp. On People's Exhibit number 1, Judge. Pausing at 1927-49. Sir, in your testimony, you indicated that you arrived to the gas station in a vehicle, correct? All right. Do you see that vehicle?
Yes.
Thank you.
And do you see that vehicle in this frame?
Yes.
And if you can just verbally describe where is your vehicle?
The opposite pump of the white Hardy or whatever that is.
Let's do it this way. What color is your vehicle?
Red.
Okay. What portion of your vehicle do we see in this frame?
The rear.
Okay. You see that timestamp 49 at the top?
Yes.
All right. Is it your vehicle directly under that timestamp 49?
Yes.
All right. Resuming at 1927-49. Just for judicial economy and just simplicity, I'm going to instruct the court at the moment that I believe is the most relevant portion. It'll be within probably 30 seconds.
Okay.
If I can ask the court to focus in on the individual on the left side of the screen wearing all black. I'm going to ask the court, pausing at 19:30-31, I'm going to ask the court to focus in on the second individual on the left side of the screen now wearing all black. Pause on my screen, 19:30-43. If I can ask the court to focus in intently at the passenger side of the red vehicle under the timestamp of 43. Fine. Stopped at 19:31:24. Permission to publish People's Exhibit number 2, Your Honor.
Yes, sir.
Yeah, Your Honor, People's Exhibit number 2 is camera footage from camera 12. Again, there's multiple time associated with this video. I'm going to play approximately 2 or 3 minutes, starting at, I intend to start at 19:31:00. For the record, playing at 19:31:02.
Are you playing it right now?
Oh, sorry, Your Honor.
Because I'm not seeing anything.
I'm sorry, Your Honor. Playing at 19:30:49. Pausing at 19:31:37. Sir, in this frame, how many individuals do you see?
In this frame, one,
All right, who is that person?
me,
Judge, my apologies, I'm gonna have to go back to People's Exhibit number 1 for one last question, I believe, for my witness.
Okay.
Playing at 19:30:43 of People's Exhibit number 1, I'm gonna pause at one specific frame, Judge. for the record, pausing 19/31/02. Are you in this frame, sir? Can you see it closely or no?
I can see it closely. Yeah, I believe I'm still in the car.
Okay, I'll do this. Do you recall what you were wearing on that day, sir?
Not really.
With the court's permission, Judge, I'm going to bring my laptop toward the my witness and play a portion of People's Exhibit number 1. It will still be on the share screen.
Okay.
Let me just look here. Sir, did you see a person pausing at 19/31/08? Did you see a person flee from that red vehicle?
Yes.
You recognize that person?
Yes.
Who is that person?
Yeah.
Last question. Sir, earlier in your testimony, person 1, the person who you said got into your vehicle with a firearm.
Yes.
Okay. Did you see that person point that firearm at you?
Yes.
Okay. And do you recall where it was pointed specifically, if you can remember?
I don't know. Upper body.
Okay. Nothing further from this witness, Your Honor. Thank you.
Cross-examination.
Good afternoon, Mr. Neighbors.
Good afternoon.
Can you hear me okay?
Yes.
All right, Mr. Neighbors, you said your plan was to go and get some gas and to sell some gummies, is that correct?
Pretty much, yes.
So you had prearranged for this transaction before you got to the gas station, am I correct?
Yes.
And how did you prearrange this transaction? Did you use
Telephone, selling, save the phone.
Did you call the person up or did they call you?
They called me.
And did you recognize the person who was calling you?
No.
Didn't recognize the number?
No.
And was this a short time before the incident? Was it a day before?
Short time before the incident. Maybe 30, 45 minutes before.
Did the individual identify themselves?
No.
And the individual, did they know your name?
No, I don't believe so.
And how many times did you have communication with this individual who wanted to make a purchase from?
Twice to set up the purchase and tell them I was on the way.
So you set up the place and the time that you're going to be at, correct?
Right.
Did you tell them what kind of vehicle you were in?
I'm not sure.
Okay, did you describe your physical appearance, how you look?
No.
And you didn't recognize the voice from an individual you had spoken to before, correct?
Correct.
And you had only, within that matter, the short period of time, you had only communicated with one individual, as far as you know.
Right. Yes.
So the plan was to sell these gummy bears. Was there an amount and a quantity?
Came with like $100 worth of stuff.
Now, making a purchase like that, or making a transaction like that, did you inquire as to who the person was?
No.
Did you inquire as to what kind of vehicle they were going to be in?
No.
Did you inquire as to whether or not they were armed?
No.
You just said, come on, meet me at such and such a place at such and such a time, right?
Yes.
Now, the two individuals that you testified to today and identified, did you ever see them get out of a car?
No.
So you don't know how they arrived or at what time they did arrive. Is that a fair statement?
Yes.
And after you had been shot, did you see them get into a vehicle?
No.
Now, you were carrying a weapon yourself that day, is that a fair statement?
Yes.
What kind of weapon were you carrying?
Compact 9mm.
And did you ever discharge that weapon inside of your vehicle?
Yes.
How many times?
I'm not sure, 2 or 3.
So you fired first. Would that be a fair statement?
No.
Well, let me go back a little bit. All right, so you have this meeting that's about to take place. You don't know who you're meeting with, correct?
Correct.
You don't know how many people you're meeting with, correct?
Correct.
And it's your testimony that you're just sitting there, well, basically, you're just waiting for these individuals. Although you said you were going to get some gas, you didn't make any attempt to get any gas, right?
Right.
You were basically waiting for whoever you had communicated with to come and make this transaction, right?
And then I was going to get the gas.
Right. So when the person jumps in your car, do they say anything to you?
Yes, it said run your shit.
The person who was always outside of the vehicle, did they ever say anything to you?
I didn't hear him say anything.
You didn't hear them?
The person outside the vehicle, I didn't hear him say anything.
Right, and did they ever, you said they approached your vehicle from the driver's side or the passenger side?
One was coming from the driver's side, the other one coming from the passenger side.
Okay, so someone approached you from the driver's side?
Yeah.
But initially, they didn't say anything to you, right?
Not the driver, not the one at the driver's side, just the one inside the car.
And initially, you didn't see any weapon or anything in the hands of that person who was outside, correct?
Not at first, no.
It wasn't until gunshots went off that you saw that individual outside with a weapon, right?
Right.
Now, what's your dominant hand, your left or your
My
right?
right hand.
So it's your testimony that you reached with your non-dominant hand and you were fending off this other individual from producing a weapon, and you were able to shoot at that individual all at the same time, correct?
I believe so.
Now, you said that you were robbed. Was anything taken from you?
Yes.
What was taken?
All of the edibles and stuff I had with me.
The what?
The edibles.
Where were they located?
On the passenger floor.
On the passenger floor. Did you?
It was a bag.
Did you see someone take those? Did you see someone take that bag?
No, I did not.
And when you gave a statement to the police, you never told them anything about this bag of edibles being taken. Would you agree? If you want to
remember, it's all remember what I was saying because
I know, I'm sorry, I apologize. If you want to see your statement, would that refresh your recollection?
Yes.
Okay. Your Honor, may I approach the witness?
Yes.
I'm handing you a 4-page statement, which is purported to be a statement given to you, given by you to Detroit Police Department. If you can look at that document and review it to yourself to refresh your recollection, please. Had a chance to review your statement, Mr. Neighbors?
Yes.
Does that refresh your recollection as to whether or not you told them about this bag of gummies?
Yes.
And it's not included in your statement, would you agree with that?
I agree.
Okay, thank you. And your cell phone, did you ever receive your cell phone back, or was that taken into evidence?
This is evidence.
And the handgun that you had,
This
likewise?
is evidence.
Okay. Now, you were able to get out of the car and you, it seems like where you hit while you were in the car, or it wasn't until you were outside of your car?
I would say inside the car and outside of the car.
When you were outside the car, were you ever struck by a bullet?
Yes.
How many times?
At least once.
Okay, and you don't know by who, do you?
No.
And I have nothing further, thank you.
Mr. Clements?
Yes, very briefly, Judge. Good afternoon, Mr. Neighbors.
Good afternoon.
Mr. Neighbors, I'm gonna ask you some questions. If I speak too fast or ask you a question you don't understand, just let me know and I'll try to ask you a better question, okay?
Okay.
How were you going to recognize the individuals that you were there to provide the edibles to in exchange for money?
I was texting them to tell them what kind of car I was in.
Okay.
What kind of car I was gonna be getting out of.
So you would have expected then that they would have contacted you once they arrived at the gas station? Is that a guess?
Yes.
Did that ever occur?
No.
Were you ever shown any photographs in relationship to individuals that were suspects in this particular case?
No.
No one gave you a photo array of individuals to look at?
No.
Okay. Specifically, was there a particular point in time when you were interviewed by detectives in relationship to this case?
Yeah, the second day I was in the hospital.
And at that particular time, were you under pain medication?
Yes.
All right. Now, you had an opportunity to review your statement, correct?
Yes.
And you and I agree that there's nothing in your statement about any property being taken from you, correct?
Correct.
Okay. And you really can't say whether or not anything was taken from you or not, right? Who's responsible for that?
Um,
Well, let me ask you a better question. I'll withdraw that question. You never went back to the vehicle after you were shot, correct?
not directly, I can know.
Okay. And in relationship to, you also testified that the individual that got into the front passenger seat, that they had a firearm as well, correct?
Yes.
Would you describe that firearm to the court?
It was a handgun. That's all I really know.
Now, you have some familiarity with guns, right?
A little.
Okay, you're able to decipher the difference between a semi-automatic handgun and a revolver, right?
Yeah.
Okay, and in this particular case, you can't tell the court whether or not this individual had a semi-automatic or a revolver?
No.
Okay, are you able to give the color of the type of weapon that this individual had?
It was black. I just remember seeing a girl. That's all I remember seeing.
All right, now, you ultimately shot that person that was in your front passenger seat, is that correct?
I tried to. I don't know if I hit him or not.
Okay.
Pardon me, I didn't hear your answer.
I tried to shoot him. I don't know if I hit him or not.
Okay, and you would agree that you fired that shot in the direction of where that individual was sitting before any shots were fired at you, correct?
No.
Okay, well, let me ask you, the sequence of events then, is it your testimony that shots were fired at you from the outside of the car before you fired, or were they fired at you from the inside of the car?
The inside.
So the individual that's in the front passenger seat shot you initially, and then you responded and tried to shoot them?
Right.
Okay. So from the course of events that takes place, this individual who you don't know, who you don't recognize, walks up and opens your front passenger door, right?
Right.
Where's your handgun at that particular time when they open the door?
Under my seat.
Okay. And what did you do immediately after this person opened your door?
I reached for my weapon.
Okay. And isn't it true that as soon as you reached for your weapon at that particular time, you pointed and fired right away?
I'm not sure.
Okay. You indicated, you said you're not sure, is that correct?
I'm not
Okay.
sure.
All right. You indicated there was a particular point in time where the two of you were wrestling over a weapon, right?
Yes.
Okay. So is it your testimony that the front passenger of your vehicle now has a weapon and you have a weapon and you guys are also wrestling over weapons?
It was like wrestling, like who was going to get the shot off. That's pretty much how it was, like who was going to get the shot off.
I appreciate how it is, but I'm trying to ask you, like, what happened? Are you saying that you had one hand on your gun and then one hand on the firearm that the front passenger had and vice versa? Is that your testimony?
I had one hand on my weapon, and I was also trying to knock away his weapon from getting a clear shot at.
Okay. And it's your testimony that you didn't fire a shot until a shot was fired at you?
Right.
Okay. And this individual that was in the front passenger seat fired a shot at you first, right?
Yes.
Okay. Are you certain about that?
I heard the shot.
Okay. So when you said you heard a shot, you don't actually know whether or not the front passenger fired or if the shot came from outside the vehicle, correct?
Correct.
Okay. And in reality, in this particular case, the front passenger side window, were you in the vehicle while that front passenger side window was shattered?
Yes.
Okay. And that's the shattering of that window occurred after you fired your gun, correct?
I believe so.
Okay. Well, and when you fired your gun, you were attempting to kill that individual in the front passenger seat, correct, in self-defense?
Yeah, right. There's that.
All right. How do you know that the individual that entered your front passenger seat isn't the individual that has been communicating with you?
Because I never told him what car I was in.
You corresponded with that individual on the phone, right? You talked verbally, correct?
Right.
This wasn't a text message communication, right?
Right.
Okay. So they heard your voice, right?
Right.
Okay. You told them what type of vehicle that you would be in, correct?
No.
You didn't give them a color either?
No.
Did you get a call or
I was
comment?
gonna do all that once I got to the gas station.
Why didn't you tell the police that you were there? When you spoke with the police, why didn't you tell them that you were also there to serve somebody some marijuana edibles?
Because I don't know, I thought I'd get in trouble.
So because you thought that you could potentially get in trouble, you deliberately gave them less information than what was true?
Yes.
And in this particular case, sir, the individual that got in your front passenger seat, have you seen that person before?
I didn't recognize him right away. He had the hood on and stuff.
But what I'm saying is, I appreciate you didn't recognize him right away, but you've identified him now as this individual here, right?
Right.
Would you agree that you've interacted with this individual before?
Yes.
Okay, so this wasn't a stranger to you, correct?
I mean, I interacted with him 1 or 2 times before, but he was still pretty much a stranger.
Okay, do you and this individual have friends in common, people that you know?
Just one.
Okay, what's that individual's name?
Real.
Okay. Does he have a full name or you just call him Rail?
Just call him Real.
Okay. Did you have any communications with Rail regarding this individual meeting you on that particular date and time?
No.
Okay, you're certain about that?
Yeah.
Okay. Do you recall the phone number of the individual that you communicated with who you were supposed to serve on that particular day?
No.
Okay, did you ever erase that number from your phone after the communication with them?
I don't think so.
Okay, so the phone was intact from the time that you were shot until, at least as far as you know, until the police recovered?
Right.
Yes?
Yes.
These individuals that were involved in this shooting with you at the location, Do you know whether or not they fled the location or they remained there?
So I'm running off, I don't know exactly if they left the whole location, but that's what I'm running off.
Now, ultimately, you had an opportunity to look at People's Exhibit 2 while you were laying on the ground. You were struck, correct?
Right.
Correct?
Yes.
And is that the same individual that's saying that, when I say struck, I'm talking about kicked you while you were on the ground, right?
Right.
Would you agree with me that that's the same individual that was in your front passenger seat?
Yes.
Okay. And when you had an opportunity to look at that second exhibit, he didn't point a gun at you at that particular time, right?
I'm not sure.
Well, you watched Mr. Carter play the video for you while you were on the ground, right?
Yeah.
Okay. And at that particular time, he didn't point a gun at you, right?
I don't think so.
Okay. He didn't make any efforts to shoot you at that particular time, right?
At that particular time, no.
Didn't make any efforts to take your gun or anything of that nature, correct?
I didn't hear the response.
Pretty sure that's what the kick was about. So
Okay.
he slapped my weapon out of my hand.
Okay, but then after you dropped the weapon, then he turned and ran away, right?
Right.
There were no additional shots fired, correct?
I don't think so, no.
Okay, thank you. Nothing further, Judge.
Can you redirect?
Yes, just briefly, Judge. Okay, so Mr. Neighbors, I'm gonna kind of clear up a few things. All right, so Mr. Clements asked you a wide array of questions, correct? Question after question. I want to go ahead and break that down. Mr. Clements talked to you about what's called a sequence of events, correct? Correct. All right. He said who shot first and who wrestled over the gun first and so on and so forth. You recall that line of questioning? Yeah. All right. At some point, the person that you indicate got into your vehicle first, inside your front passenger side. He made a statement to you, right?
Yes.
And what was that statement?
Run your shit.
Okay. Was a shot fired before the statement, run your shit, or was it fired after run your shit? Nothing further, Your Honor. Thank you.
Nothing further on behalf of my client, Judge.
No further requests.
Thank you. You may exit the courtroom, Mr. Neighbors. Thank you so much. Next witness for the prosecution.
Judge, I have two additional witnesses in the hallway. Judge, the people have no further witnesses to call. I believe my elements have been met. I'm ready to make an argument.
Are there any witnesses for the defense?
Not on behalf of my client, Mr. Johnson, Your Honor.
Oh, no.
Okay, on behalf of Mr. Matthews, no?
Yes, correct, Judge.
Okay. That being said, is there a motion?
If I may, Your Honor?
Yes.
Your Honor, I think, based on the evidence, Judge, I believe this is a question of fact. Of course, there are issues that can be flushed out, whether who fired the shot first, whether or not Mr. Neighbors shot himself in his own hand, as I believe some of the questions, the innuendo behind the questions, I believe, from Mr. Ray Blake's cross-examination. But here, I think the evidence, the physical evidence in itself is damning, Judge. I believe in the people can play Exhibit 1 and 2 again for the court. What this court can see with People's Exhibit number 1 is the complaining witness arriving at a gas station in a red vehicle. We see two individuals, defendant number 1 and defendant number 2, kind of mulling around, if you will, right before the ultimate incident. We see Mr. Matthews go into Mr. Neighbors' vehicle, and we don't see anything for a second. Now, we heard the testimony from Mr. Neighbors that at that moment, Mr. Matthews got into the vehicle and said, "Run your shit." Mr. Neighbors indicated that to him, that meant that it was a robbery. Mr. Neighbors indicated that he saw Mr. Matthews, the defendant, actually defendant number 2, retrieving a firearm and pointing a handgun at. He indicated that, at least on direct examination, Mr. Matthews fired a shot. He and Mr. Neighbors indicated that while he was inside of the vehicle, he was shot in the hand. We can see that further on, People Exhibit number 1, Mr. Neighbors exits his vehicle, going toward the gas station. We can see that Mr. Matthews is actually grabbing and attached to Mr. Neighbors' action. Defendant number 1, at this time is seen, I think it's clear, seen with a handgun, firing that handgun. We know from the testimony of Mr. Neighbors that he was also struck in his back as well, Judge. Now, for the charge of assault with intent to murder, we know that it's based on the intent can be formed by the type of weapon that was used and the manner in which it was used. I mean, if people have two theories ultimately, and both are charged as principals, and both can also be charged as aiding and abetting theory as well, Your Honor. Now, we know that handgun was used. We know multiple shots were fired, and I believe that supports the charge of assault with intent to murder. As to the charge of robbery armed, Your Honor, Mr. Matthews getting into that vehicle saying, run your shit, run your shit. That's language consistent with a robbery. It's an armed robbery because the gun was used. Now, at that moment for the armed robbery, the people charged defendant number 1, Ronald Johnson, on an aiding and abetting theory at that moment, because he's the muscle. He's the additional muscle right there. He's in the back with the gun, arm clearly extended, firing shots. And ultimately, Judge, once the initial melee is over with, we see the complaining witness fleeing into that gas station, dropping down because he can no longer walk anymore. And the court can actually see Mr. Matthews actually pursues him a little bit more. The people's position that he wants to further and complete that robbery, if you will. But nonetheless, Judge, based on the evidence, at least by a probable cause standard, it supports all of the charges. The people would ask this court to bind both defendants as charged. And lastly, Judge, regarding carrying a concealed weapon, 2 theories with that for defendant Matthews. The court can see who Mr. Neighbors identified as Mr. Matthews outside of the vehicle. No gun is actually seen, as not in plain sight. And the second theory is that he was inside of a motor vehicle with Mr. Neighbors, Your Honor. So again, people would ask this court to bind both defendants over his charge. Thank you, Your Honor.
Counsel?
Judge, we would oppose the bind over with respect to Ronald Johnson. Although we've seen video, Judge, and we've heard testimony, there are a lot of unanswered questions. Why would someone rob an individual that they had telephone communication at a brightly lit gas station where that individual would know them? But that can be settled on down the road. If you look at the role of allegedly my client, he doesn't say anything to the complainant, doesn't get into the car. Apparently, he doesn't take any action until after shootings between 2 individuals in the car. So assault with robbery armed, it's a specific intent crime. My client doesn't say anything about giving the money, giving the gummies, which doesn't make any sense that this individual is selling THC gummies, which you can buy at a drugstore probably for $10, but there are high stakes here, and I imagine it was probably, if anything, more than gummies, but you have to look at the credibility of these individuals, Judge, including Mr. Neighbors. Unfortunately, he has horrific injuries, but the prosecution's theory is aiding and abetting, or that my client is a principal. Once again, there's communication. Mr. Neighbors didn't identify as previously knowing my client, and he doesn't know if these clients are even working together. He doesn't see them arrive, he doesn't see them leave. So when counsel says aiding and abetting, you know, there are other individuals out there, pedestrians, who knows, if he was there just hanging out and, you know, tried to help an individual, be a good Samaritan, because you don't know who's the bad guy in this situation. If you're standing out there looking at the video, you see other people running, reversing their vehicles out of there, trying to get the heck out of it. So Judge, with respect to the more serious charges, once again, the mens rea is not there for the robbery arm. It's not there with the assault with intent to murder. With respect to the other charges, we'll leave it to the court's discretion. Thank you very much.
Mr. Clemens?
Judge, oftentimes we come before the court on preliminary examination and we show up at a preliminary exam and all of the burden of proof is lower and all the government has to do is establish whether or not there's a question of fact. We shouldn't leave the preliminary examination with more questions than what we came in with before the exam started. In this particular case, you have the individual who's the complaining witness and victim in this particular case, and it is most unfortunate that he's paralyzed, that he suffered permanent injuries and things of the like. But when we have an opportunity to speak with him to discuss what happened to him in a particular day, I mean, and I do give him credit that he's overwhelmingly honest, but also we have to look at the texture of the testimony in terms of, by his own admission, he reveals that he was disingenuous with the police, that he provided a different account of the events than what actually happened because he was afraid he was going to get in trouble. And then from there, we transition to what's actually in the physical evidence that's what's in display. His testimony is that Mr. Matthews enters his vehicle, and it's got to be a note that he knows who Mr. Matthews is, right? And that he never provided that information to the police, that he knew the individual that shows up at the location when he's trying to serve someone who he tells the court in his testimony, I don't know who this person was. Can't give you any information as to how he was going to connect with them other than I thought that they would call me when they arrived. So then we graduate from there and we actually look at the video, and if the court concludes for these purposes that it's Mr. Matthews who strikes him while he's on the ground. Now, Mr. Neighbors tells the court that while they're in the vehicle that Mr. Matthews is armed with a handgun. I mean, you see Mr. Matthews, or who's been identified as Mr. Matthews, on multiple different frames of both exhibits. You don't see him with a handgun. He can't describe the handgun. There's no handgun that was recovered and entered into evidence for these particular proceedings. Yet the people are asking you to conclude that they provided sufficient proofs that Mr. Matthews had a gun on that particular day. Well, that I would submit to the court that flies in the face of what's actually depicted on the video. He's not seen with the gun. In fact, he's seen trying to wrestle the gun away from Mr. Neighbors. And by Mr. Neighbors' own admission that he thought that he was kicked while he was on the ground to dislodge his weapon. And then after that happens, the individual that he identifies as Mr. Matthews turns and runs away. So my question is, where is the intent on behalf of Mr. Matthews to kill this individual if he's on the ground, still clearly alive? And what Mr. Matthews didn't know at that time is that individual was paralyzed. So he couldn't have defended himself further even if he wanted to. So where's the intent to kill? So, Judge, I think what you have here is you have insufficient proofs. And for those reasons, Judge, I'm asking the court dismiss the assault with intent to murder, bind over on assault with intent to do great bodily harm, dismiss the carrying a concealed weapon, because the proof, the texture is just not sufficient. I don't have anything on this video to show that Mr. Matthews ever had a weapon. And the government did the video, and I submit to you it cuts against their own witness. So for those reasons, I'd ask that the CCW be dismissed. I'd ask that the assault with intent to murder be dismissed as well. Thank you, Judge.
Mr. Carter?
Just briefly, the defense's argument is on the notion that the only evidence before this court is People's Exhibit number 1 and People's Exhibit number 2. That's not the case, Judge. We also have the testimony of Mr. Neighbors, who described accurately and in detail and honestly. He indicated some things that he didn't know. He indicated that Mr. Matthews actually had a gun, produced that gun, fired a gun. Judge, the testimony on this record supports all of the elements for all of the charges, at least on the probable cause standards, Your Honor. And I'll ask this court to bind over again on all charges. Thank you, Judge.
Thank you. So, it is a probable cause hearing, Mr. Johnson, Mr. Matthews, and a lot of attorneys, when they come in here representing their clients on the day of an examination, talk about the low threshold, and I presume because it's not very well liked, but it is what it is. This is the phase of the proceedings where that is the burden on the prosecution. I can't change that. Defense attorneys, even if they talk about how despicable that might be, it is the burden on the prosecutor to establish by a probable cause standard. That's a term of art that we use that many people who graduate from law school still can't describe, but it's something that's worth having a conversation with your respective attorneys about what that means. This is not a trial. Today is not a trial. The burden of proof required to be met by the prosecutor is not beyond a reasonable doubt. Today is the examination. The purpose of today's proceeding is to see whether or not the prosecutor has sufficient evidence to move forward to a higher court, wherein the burden of proof does rise significantly to that beyond a reasonable doubt that you hear about. So Mr. Carter took the words right out of my mouth. It isn't just the videos, exhibits 1 and 2 that the court is reviewing. It isn't just the testimony of Mr. Neighbors that the court is reviewing. The court is reviewing both the videos and the testimony of Mr. Neighbors in what's called the totality of circumstances we often talk about, so that there can be a determination as to whether or not there's enough here, there's enough there to move forward. That's what today is about. So I just always like to stress that and be abundantly clear with what my job is today in assessing what the prosecutor has brought forth. So again, there's been in court today, Mr. Neighbors had testified rather succinctly as it relates to in-court identification. He didn't wobble, he didn't seem to be uncertain about that. He was able to identify both Mr. Matthews and Mr. Johnson. Mr. Matthews as the individual that stepped into the car, Mr. Johnson as the other individual that appeared by way of testimony and by way of review of the video to be working in tandem. And no, I was not able to, in merely looking at the video, make a determination rather as to whether or not I could see a firearm. But there was testimony that was provided from Mr. Neighbors, who struck me as rather credible witness. There wasn't something about it that made me think, oh goodness, well, I wonder if he's fibbing here. The testimony was, from my estimation, he was attempting to be very candid, even to the extent that he did indicate to Mr. Clement's question that he did not tell the police everything about what he was doing there, because he was scared he might get in trouble. That's what he said. But that in and of itself doesn't make me come to the determination that, well, everything that Mr. Neighbors is saying cannot possibly hold water. The testimony that Mr. Neighbors provided was that he saw the firearm that was pulled from Mr. Matthews. He said he was wearing a hoodie and presented that firearm, and also referenced Mr. Johnson as the other individual to have also been shooting. That was like it or not, that was the testimony that came on the record. So, I certainly don't want to fall short of addressing Mr. Johnson, your attorney's argument that there's lacking of mens rea on the record here. That's a question of fact. As I indicated, this is not the trial. Has there been enough information presented by way of testimony and videos as People's Exhibits 1 and 2 that would cause this court to make a determination that this should move forward to a higher court is there a question of fact that needs to be determined by the fact finder? And this court does find that the prosecution has cleared that hurdle. Maybe more verbiage than counsel would like, but I always think it's important to explain, Mr. Matthews, Mr. Johnson, what this process is about. So you walk out of here with a very clear understanding of what my job is to do. And again, I do find the prosecutor has met that burden. The matter will be bound over as it's charged, including the CCW for Mr. Matthews. And the AOI date is going to be August 3rd, as you're both out of custody. August 3rd at 9 a.m. Is there anything further?
Nothing further from the people, Your Honor, thank you.
No, Your Honor, on behalf of Mr. Johnson.
No, thank you.
Okay, thank you.
All right, Your Honor, so we,
Oh, yes, sir.
have a good one, Madam Clerk.
You too.
Madam Clerk, reporter.
I don't have any exhibits, I don't believe. There were just the videos, so yes.
Thank you, Ben. I'm notorious for leaving them in here.